Yeah, but under common law, or is it military and tribune? Because also with
Oh, I've been waiting for something like this for so long. This is so much fun.
I'm just trying to see what's the.
You have the right to
I
walk.
have the right to travel, don't I?
Yeah, I'm taking your happy-go-lucky feet. You want to travel? Take those 2 feet to travel, not in a car.
Just what the 14th Amendment was saying, like I have the right to travel.
You do. Yes, and you can walk your happy ass from one part to the other part. Not in a car, though. I mean, you want every single witness in Harris County? That's what that's asking for.
You have to properly represent myself with the case.
That's 4.2 million people. Really? Really? I mean, you're saying a true and complete original and or certified copy of the alleged is not even spelled correctly.
That's why I travel very cautious. I don't.
You just said I drive.
I'm saying I
I
travel very
drive. You
cautious.
said the magic words.
I was a driver.
Come on. Don't be Helen Keller. Come on. All right. So today is September 11th, 2024. It's approximately 12:25 p.m. We are now in court 5. In front of me, I have Eaton Emitum, case number 2522688. Would you please identify yourself for purpose of the record?
Living man, Eaton Emitum.
Would you please raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth to help you God? That you're going to tell the truth. That's it. Yes? Okay. State, would you identify?
Petrov on behalf of the state.
Okay, so the reason that we're putting this on the record now is Mr. Emitum has been charged with the offense of unlawful carrying of a weapon. The case is 40 days old. It appears that probable cause has already been found. I don't know if I did probable cause on this, or if I don't know if another judge did, because I don't remember Mr. Emitum, and I was out a week. Yeah, lollygagging. So let's just do it for.
On August 2nd, 2024, officers observed a car without a front license plate, changed lanes without a signal, and have expired registration as of March 2023. Upon approaching, officers smelled marijuana. PC search returned 4.17 grams and a loaded Smith & Wesson handgun. Additionally, there was a backpack with 3 checks that did not belong to him. Officer called Kumamoto, who said the checks were stolen from her restaurant on July 8th. When defendant broke the front window, went to the back where the checks were kept in the office, broke the hinge of the back door and exited.
So as a result, because of that, he was charged with felony fraud on that one, on the check. Okay. Yes, he has an open case in the 182nd. Looks like he made a $15,000 bond. With us, I am going to find there's probable cause to go forward. Well, hold on a second. We'll get there. I'll let you say your piece, but do you have a Texas driver license?
I have a U.S. private property number with the FMCSA. What my vehicle was on there, it was sticker tags, everything with my business, the Emitum Estates. That's with the Department of Transportation.
Is that from the state of Texas or from where?
This is federal. This is with the Department of Transportation.
Okay, but you still need a Texas driver license, and you need registration and
I did
on a
all my
vehicle.
best with them because it was private property that I had. They said I didn't, if I didn't need to get registration with the state of Texas because I registered it. And they said that would be my voluntary, but since it's private property, I wouldn't have to register it.
Okay. From what I know of the law, you need a Texas driver license to be able to drive.
This is, what jurisdiction is this case being tried on? That's what I'm trying to, because I'm kind of don't know what it's being tried on.
It's
Criminal, civil?
criminal, yeah,
So
right? You're facing jail time, right?
I believe so. But
Weren't you taken to jail?
Yeah.
So that wouldn't lead you to believe it's criminal, right?
Yeah, but under common law, or is it military and tribune? Because also with
Oh, I've been waiting for something like this for so long. This is so much fun.
I'm just trying to see what I'm being tried on, because what I was told with the US side, I wouldn't have to register with the state of Texas with the registration or licensing. I do have my own plates with that vehicle too as well. So
Do you need a license to drive? A Texas driver license. That's it. You either have one or you don't. The federal government has regulated to the states through the Constitution that they have allowed the states on their own initiative to create laws regarding driving on highways and byways. So that's why you see every single state has different requirements for licensing, insurance, mode of transportation. The federal government has somewhat to do with it, but by and large, they have delegated to the states that they are their own entity with regard to creating laws in their specific highways. So that's why every single state has a different type of license, different type of insurance. Like the Texas driver license is what, white versus Arkansas might be yellow or red, or Hawaii might be. So that's every single state has their own laws with regard. In Texas, you have to have a Texas driver license. You also have to have liability insurance as a minimum in the event that you get into an accident. Those are the two main requirements that you need to drive. If you're going to drive a vehicle, it also has to be registered so that they know that you're driving the vehicle and that you own it or have the right to have that, so it's not a stolen vehicle.
I own the vehicle and everything. When I was here the last hearing with the judge, like what he was saying, he said that when it had applied to me, but he was going to see what they were going to say about the other court, about the probable cause of stopping me, because he said registration when it had in the front license plate, when it had applied to me.
It does apply. It applies to everybody. Everybody has to have a back license plate. They also have to have a front license plate. And so much, they also tell you where it has to be on the car. They regulate, you can't put it in the windshield.
State, right?
State,
Yeah.
right. They tell you where it has to be. You can't put it on the windshield. You can't put it on, like on, what's it called? On the light. It's got to be right there. They even tell you how many centimeters it's supposed to be from the street to the actual place on the car. That's how bad the state of Texas micromanages all these things. They even tell you how many damn centimeters it's got to be on the car. So you have to have a front license plate. You got to have a license, got to have insurance. So if you don't have that, you can't drive. And that's it.
Yeah, I did tell him I was traveling. I wasn't arguing with him, but I was traveling. I wasn't making commerce. I used to do medical transportation, so I'm kind of aware with licensing and registration and everything. That's why with my private vehicles, I did that with the US DOT instead of the state. And I didn't know that was
Correct.
interference. They
You
said
need a license. It doesn't matter whether you're saying you're conveying, whether you're traveling, whether you're, driving. It's a privilege. It's not a right, right? There's a big difference between a privilege versus a right. You have the right to
I
walk.
have the right to travel, don't I?
Yeah, taking your happy-go-lucky feet. You want to travel, take those 2 feet to travel, not in a car.
Just what the 14th Amendment was saying, like I have the right to travel.
You do. Yes, and you can walk your happy ass from one part to the other part. Not in a car, though. Not without a license and insurance.
Was on there from what I did this with the Department of Transportation. They said automobiles were on there, carrier, bicycles.
They're wrong. I'm just telling you now, they're wrong. Whoever told you that, whoever, where you got that, it's complete. Because imagine this, Mr. Emiton, and I've seen this before. Imagine that you get into an accident, right? And you kill a 5-year-old kid. What's going to happen at that point? Whoever owns that car, the other people, they're going to come after you. They're not going to go after they're going to come after you. The first thing they're going to do is, do you have insurance? And if you don't have insurance, they're going to sue you. And then they're going to attach a lien on absolutely everything that you own to satisfy the judgment they get against you. And they will take your house, they will take your car, they will take your bank account, they will attach to where if you ever want to start working and get a paycheck, they're going to garnish all that money. You have insurance, liability insurance, so that if you ever get into an accident, you don't mean to do it. You didn't mean to kill the kid. It's not an purposement. It's an accident. And accidents happen. You might be looking at your phone, you're looking at, this pretty girl that's walking across the street, and then boom, you have insurance so that if that happens, the insurance company will pay on your behalf, so you don't have to pay out of your own pocket. And they will even give you a lawyer to represent you on your behalf, because that's what you pay for when you get insurance. If you get into an accident, lawyers usually call you and say, hey man, tell me what happened. Was it your fault? Or was it the other people's fault? Because we want to know who to pay. And that's why for $30 to $40 a month, you get insurance for that very purpose. And I've seen people come here, they have killed someone and they get a $250,000 judgment against them. I've seen it. And God, you'll never dig yourself out of that. So the conveying, the this, that, you need a license. You've got to have insurance. And we do it with every single person that comes here.
Can I say for the unlawful carry, the possession of marijuana, the person that was in the vehicle told the officer it was legal hemp that they got from the store. They have receipts and everything in Texas. You can have legal hemp. They got it from the store. Even told the officer it was theirs. He pulled me out the car. He didn't ask for any paperwork.
Now you're making apples and oranges, right? Now we got to test it. Is it weed?
Oh yeah,
Is it him?
That's it.
Understand that takes time, but you also need a lawyer to represent you.
I found my own discovery. I was representing myself pro se.
And you can do that if you want.
Yeah.
But we have to go through a series of questions.
I represented myself plenty of times. I had dismissals here from
Remember,
County.
and for purposes of the record, so Mr. Emitom had a case with me here. It was actually June 7th of 2022. He was charged with another gun case. And that was with Victoriano. God, that was a great DA too. And I found no probable cause in that case, right? So you didn't represent yourself in that case. I found no probable cause and they dismissed it. They didn't have to dismiss it, but they did dismiss it. So other than that case, have you ever represented yourself?
Yeah, many times. I have dismissals all through here from Harris County. Traffic violations.
You're welcome to do it, and who's one of the worst, who's one of the best presidents that in history that you can think about right now?
Wonderful to me right now.
You can't think of one good president that we've ever had?
I don't know any.
Abraham Lincoln, he wasn't good?
I never met him. I don't know about him at that time.
Abraham Lincoln said something. He goes, you know what? He who represents himself has a fool for a client. That's what he said. Meaning that when you represent yourself, there is an inherent conflict and there's an inherent bias, and you may not be able to see things objectively, meaning that you have your heart, you've got your soul into this case. So you may not be able to see from an outside position if they're saying something that makes sense. You're absolutely entitled to represent yourself. And if you want to do that, you're more than welcome to it. And I have no problem with you doing it. You need to understand though, if you represent yourself, you can't come at a later day and say, you know what? I had ineffective assistance of counsel. My lawyer sucked. Well, you represented yourself. You now can't complain about that. If you go to trial and you lose and I end up putting your butt in jail for a year, you can't complain. You're stuck like Chuck for a whole year because that's what you're facing. You're facing a year in jail and you got a bunch of other documents too that, so
My discovery from that last month that I filed.
well, let's do the question. So what is your full name?
Eton, she's Roque Amaton.
Okay. How old are you?
I'm 34.
Where were you born?
In America.
Were you born here in Houston? Were you born in?
From Texas.
Okay. You read and write English, right?
Yes.
Okay. Do you have any learning disabilities or communication handicaps? Have you ever been declared mentally incompetent or treated for any mental health disorder? Okay. You said last time I asked you about your educational background, you graduated from high school.
Graduated high school, some college.
How far did you get in college?
2.5 years.
Did you do any legal courses whatsoever?
Left that and I started doing medical transportation. I was taking classes for paramedics. I was just doing my basics. I was doing my basics.
Studying in college.
I was just doing my basics. I ain't getting into it. Yeah.
Yeah, I mean, that makes sense. And when you're beginning, that's all you do anyways, right? Do you have any legal training, education, or experience?
I've had experience with dealing with the court being charged before.
And any other legal? Do you know about the Code of Criminal Procedure?
Yeah, I'm familiar.
Do you know about the Texas Penal Code?
I'm familiar, but I'm not too familiar with a lot of statutes and codes.
Were you here for our earlier trial?
No, I went up.
I know you went to the felony court, but we were in trial earlier. Did you see what happened in trial earlier?
Got like a glimpse of it walking.
Okay. What I'm trying to say is that the lawyers on both sides had to introduce evidence. There's a specific procedure that you have to follow to have evidence admitted. It's detailed in the codes. You have to know that, because once you represent yourself, I'm going to treat you as if you were a lawyer. I will hold you to the same standard. And I'm not here to put you through law school because I have way too much drama as it is. I don't need any more drama, right? So if you don't do it the right way, I'm going to shut you down, right? I like to be nice to people, but I'm not taking you to school. Do you understand this? Do you understand the charges against you?
I don't understand the nature of it.
Okay, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail. What they're saying is that you unlawfully had a weapon. As a result, you were charged, and now you're facing up to a year. Do you understand?
Yeah, what they're telling me, but I still don't understand like why I went to jail for that. So that's why.
What do you not understand?
The court procedures, or
No. I'm asking about the nature of the charges. No, it's not. Don't talk about the procedures. Don't talk about the licensing, about the conveying.
Yeah, I
No.
know I'm getting charged with unlawful care. And
Right.
Do
you understand that?
what's going on?
Okay. You have the right, or you understand the range of punishment that you're facing a year, correct?
That's what I've been told.
Okay. You have the right to court-appointed counsel. Do you want counsel to represent you?
I don't want legal advice. I don't need a legal team. I just want law.
If I offer you a lawyer now, would you want it?
them.
You really don't want a lawyer?
I represent myself. I could get none more by myself than anyone representing me.
Okay. Do you understand that you will not be able to claim ineffective assistance counsel if you lose at a later time, whether it's in trial, whether it's in a hearing, whether anything? Do you understand that? What that means is that you cannot appeal this thing. If you're found guilty and you go to jail, you know, a lot of lawyers or a lot of defendants like to claim, sorry, guys, I'll be 2 minutes. A lot of lawyers, a lot of defendants like to blame their lawyers for screwing up. And they say, hey, man, my lawyer messed up. I can tell you, like, that's the number one thing that defendants complain about. And probably, I don't know this for sure, but I would suspect probably the number one reason why cases are overturned because of ineffective assistance of counsel, meaning that a lawyer, for one reason or other, messed up so bad that their cases have to be redone. You cannot complain about that at a later time.
I've seen that many times. That's why I'm representing myself.
But you can't, if you mess up, you cannot appeal this thing. Do you understand? Once, and if you are found guilty, that's it. Do you understand? You also have to comply with the same appellate procedures if you lose, meaning that if you want to appeal for one reason or the other, you have to understand the guidelines and the timing, and you have to comply with those rules as well. Do you understand?
Mhm.
You will not be granted any special consideration because of your lack of formal training. Do you understand this? You may fail to properly raise points of error in the trial record if we go to trial. Meaning that if we go to trial and you object to something, because that's you hear that a lot, right? I object. This shouldn't be in there. You have to object properly. You can't just say object. There has to be more to it. You have to state the reason for the objection. It has to be a legal reason. You can't just say, I object, and expect me to hold something out. You have to give the legal reason. And there's a proper method that you have to state and ask me to do things for it to be recognized on appeal. And if you don't know this, you cannot at a later date complain. Well, I didn't know that. You understand? You still don't want a lawyer. I will give you a free lawyer. Is this voluntarily, knowingly, and intelligently made? No one's forcing you to do this. Okay. Knowing all this, are you sure that you still want to represent yourself? I got to tell you, I think that you look like a great guy. You look like you're upstanding. I have no problems that you represent yourself. Understand that you need to be careful what you tell them, though. Everything that you say, even if you think you're hurting yourself by admitting one thing or the other, you could be hindering your case, meaning hurting your case, even if you think you're helping yourself. Do you understand? I'll make you a deal. If at any time you want a lawyer, all you got to do is ask and I'll give you one. Really. If you ever feel like you're under the gun, that you feel like someone's taking advantage of you, I'm happy to give you a lawyer at any time. I want you to understand now, as a condition of your bond, though, I'm ordering you not to drive until you have a Texas driver license and a liability insurance. I'm ordering you not to drive. And I'm going to have you sign with me today an affidavit promising me you're not going to drive. If I find that you drive, I'm going to put you in jail. Do you understand?
Travel, I have personals.
Okay. You are not allowed to get into the driver's seat of a car and drive, convey, travel, however you want to term it. You cannot do that. And if I find that you do that, I'm going to put you in jail and I'm going to make your bond so high, your head's going to spontaneously combust. Do you understand?
That waiver my rights to anything? Or
no, but I'm telling you that you can't drive, convey, get into the driver's seat of a car. If you do, you're going to go to jail because I will revoke your bond. Do you understand? The only conditions I'm putting on you now are 3. No weapons, no picking up new cases, and don't get into the driver's seat of a car and drive, convey, travel. Are there any other adjectives that you can think of?
I'm sure there are, but
I guess I'll put et cetera so that it tries to cover any type of wording, so to speak. All right. So, Mr. Ematom, I'm going to find that you are okay to represent yourself. We need you to sign a form that you're going to do that.
Even if I don't consent to any of these charges, because I do have my paperwork, I do have.
If you don't consent, just go. If you don't think we have jurisdiction, look, if I didn't think anyone had jurisdiction over me, do you think I would be here? If I was in your shoes? Hell no, man. If I didn't think that someone didn't have jurisdiction over me to be anywhere, I'm not going there. I'm not going to get out, take a shower, put my clothes on, because I like to be naked, right? You know, I'm not doing anything like that, you know? So if you don't think we have it, just go. Otherwise, you're here. You know we do, right? Because if you...
I don't know. That's why I filed.
Let me ask you this. If you just took off now, what would happen? There you go. What does that warrant mean? What does it mean?
On, or what do you mean as far as like the warrant?
As far as jurisdiction is concerned, do you think that, look, do you think that an officer is going to go out and actually pick someone up if they didn't think they had jurisdiction to do it? Do you know how much trouble they would get in? Do you know if Stephen went out there and arrested someone now just for shits and giggles, do you know how much trouble he would get in? Right? If he had no reason to do it, do you know how much trouble he would get in? Right, a lot. He'd lose his job. He'd probably get sued. Right? Can't claim immunity. He'd be toast, Swiss cheese. So that's what I'm saying. If you didn't really think that we didn't have jurisdiction, then go.
I had to take care of this matter because
you know we have jurisdiction.
I don't know, because I was going to go to 515 arrest and file my civil lawsuit with the officer who did arrest me because they did some unlawful, unconstitutional things that they did to me at that time. So I was going to take it there. You know, I didn't believe they had jurisdiction over me.
I would wait to see how this case goes first before you do that. see how the case goes first before you start jumping the gun.
Like, that's what I was waiting.
But ultimately, if I didn't think anyone had jurisdiction over me, I'm not going to go there, man. I have enough important things to do in my life as it is. I mean, you've been sitting here since 8:30 in the morning, where it's now nearly 1 o'clock. You know what I mean? Really. Let's get this thing done. That way you can move on with your life. We can move on with our life and just everybody be happy. That's what it's about. All we want to do is protect our city. That's all we want to do, and I'm going to do it at all costs. That's it. All right. I'm going to have you sign this affidavit. After that, we'll get you out of here. And so, Mr. Emitam, you are going to have to make a plan to meet with Mr. Petrov here so that you guys can exchange evidence. He is our chief DA here. He's the one who gets all the evidence. He's the one that's going to present it to you. You can either do it here in court with us, or you can meet with them at their office, because you're going to have to get the evidence to look at it regardless. I'm happy to take any motions that you have now, and I can look at them, and then we can come back at a later date and I can roll on it for you. I see that you have a bunch of papers. I'm happy to take anything that you have and I'll take a look over it.
The clerk, last month. Motion of
Do you
discovery.
see anything?
Hey, I have the copy.
Which clerk did you file it with?
I have it right here, the copy. It was with Marilyn Burgess.
Is that for us? District clerk, right?
That's the district.
We would still get it then, right, or no?
Yeah, and the system is then filed that last month.
You filed it under this case number or the felony court case number?
No, I filed it for this one on August 9th. I have this case number on there, 2522688.
Yeah, that's it. I don't know. I don't see anything. Oh, wait a second. I see a motion for discovery. Is that it? It's a motion for discovery?
Yes,
Is that the only one that you've done?
so far.
Okay. I have to talk to officers and back. If you give me 5 minutes, let me take a look at it. And then I'm going to give you a copy so that you can look at it as well. Let me print it out. Pavel, I'm printing it out for you if you want to just take a.
Yeah, but under common law, or is it military and tribune? Because also with
Oh, I've
the,
been waiting for something like this for so long. This is so much fun.
I'm just trying to see what's the.
You have the right to
I
walk.
have the right to travel, don't I?
Yeah, taking your happy-go-lucky feet. You want to travel?
That's
Take
me.
those 2 feet to travel,
Oh.
not in a car.
Just what the 14th Amendment was saying, like, I have the right to travel.
You do. Yes, and you can walk your happy ass from one part to the other part, not in a car though.
Political.
I mean, you want every
subdivisions.
single witness in Harris County? That's what that's asking for.
You have to properly represent myself for the case.
That's 4.2 million people. Really? Really? I mean, you're saying a true and complete original and or certified copy of the alleged is not even spelled correctly.
That's why I travel very cautious. I don't,
You just said I drive.
I'm saying I
I
travel very
drive. You
cautious.
said the magic words.
I was a driver.
Come on. Don't be Helen Keller. Come on. All right, come up, Mr. Emitam. Let's go back. Can we go back on the record?
Going back on the record.
All right, Mr. Emitam, I've gotten your motion. Have you read it?
Yes, Your Honor, I've read through it.
And
Your Honor, at this time, the state wouldn't even be able to comply with this order because it's asking for an immediate order of discovery. It sounds like spontaneously going to give
well, other than
the
that,
opposing party.
I mean, and
There needs
is
to
there,
be
is he
timing
asked?
requirements, and it's not, the language is not aligned with criminal procedure or penal code. But beyond that, the only two pieces that are requested that are reasonable that I can produce with a timeline are 1 and 7.
So, Mr. Emitam, understand that you will get discovery, but sometimes it takes time. It's not immediate. It takes time to build a case, to get videos, 911 calls, reports from officers. It takes time. It's not immediate. In your motion, I guess it says he wants it immediate.
Immediate order
There's
of
just no way. We can't.
an inspection. Yeah.
But we will get it to you as he gets it, he will give it to you. I can grant you the order I will take off the immediate provision, but I can grant you everything that you want. I'll give you their case file. I can give it to you when they get it.
Yes, but Judge, this discovery order is requesting things outside of the scope of discovery,
Well, I'm not going to give him the kitchen sink. I mean, like what?
everything else. I mean, so 1 and 7 are aligned. 1 is requesting any documents, papers, books, accounts, letters, photographs, videos, which are body cam, objects or tangible things not privileged which constitute or contain evidence. Of course, I'm gonna hand that over.
Okay.
2, any and all names of any witnesses, the Harris County Superior Court, State of Texas.
I mean, that's
County of
so
Harris,
broad, Mr.
And
Emmett.
or any political.
I mean, you want every
subdivisions.
single witness in Harris County? That's what that's asking for.
You have to properly represent myself for the case.
That's 4.2 million people. Really? Really?
So that doesn't,
I mean, I'm not going to grant that. That's silly.
it's too
You want-
broad, it doesn't go into the
I
scope
mean,
of
imagine
discovery.
any and all names of any witness for the Harris County Superior Court, State of Texas, County of Harris, or any political subdivision thereof may have. That's so broad that to even try to comply with that would take years. That's, I mean, in relation to this case, yes, nothing else. Nothing else matters. The only thing that matters is this case and nothing else. So I'm happy to comply with the names of witnesses in this particular case. Yes, I will do that. And I can mark on there for this case only. Are you okay with that?
Your Honor,
Yeah, only,
in the event that you were to grant something like that, it would need to be filed by the defendant. What you're granting is what is written, not what is subsequently modified.
Okay, so I
So,
guess
The language just needs to
I'll
be
just,
corrected.
okay, so what I'm going to tell you is, you're right, Paul. I mean, right.
So I just wanted to clarify that for the
You're
record.
representing yourself. I can't do the work for you, right? He so kindly is reminding me that because I trying to, right. So that's too broad.
We can go down the list if you wish, but.
Yeah, let's do it. I mean, we have.
So 3, a true and complete original or certified alleged contract with wet ink signatures between the petitioner, the Harris County Superior Court, State of Texas, and/or political subdivisions thereof may have law states that in order for the Harris County, and he's not, it's not even citing law, valid lawful contract between the petitioner, let them bring it forward for petitioner's inspection or immediately dismiss all charges. I believe this is going into UCC. This is not.
I mean,
UCC
here you're going
contract.
into the sovereign citizen type language.
just common law.
Okay.
So, Your Honor, I will not be agreeing to
Doesn't apply
that.
here. There's no, I mean, you're saying a true and complete original and or certified copy of the alleged is not even spelled correctly, contract with wet ink signatures between the petitioner and the Harris County Superior Court. I mean,
So I'm opposed to that.
what contract?
Contract complaint, whatever. I know this is statutory and it's not going over common law, so I'm not familiar with the statutes like I explained before.
You're a lawyer now. You're gonna have to familiar yourself with it.
You're trying me on statutes. I want to be tried on common law.
You're gonna have to do it. I'm not sure. There's no common law here. It's
Interesting.
everything's done by statute. There's no common law here. It's all done by statute. And since you're the lawyer, you need to know that.
I recognize the steps of the statutory steps. That's why I don't recognize.
So
being
how,
tried in
let
jurisdiction.
me ask you this. How on earth are you gonna represent yourself if you don't even know that?
Once I get everything I need in my discovery,
He's gonna give you body cams. He's gonna give you 911 call. He's gonna give you witness lists. And that's it. Right? Is there anything else that would be in here?
going down the list.
I would, so there may be dash cam I need to check. So I haven't gotten the body cam or dash cam yet. I need to check what all this.
Mr. Emmett Tom, I mean, let's get real. If you're having problems with things of this very elementary nature, how are you going to represent yourself? I'm happy to give you a lawyer. You know, but some things are just, I mean, there's no,
We must conclude this hearing with the remainder of the list as well, and then we can go with,
Hold on, just so he knows. So number 4, a true and complete original and or certified copies of the criminal record of the attorneys of record, judge, magistrate, pro tem, commissioners, witnesses, as well as all officers of this court. Yeah,
state is opposed.
that doesn't apply here, really. I mean, you don't, my criminal history? You think I have criminal history?
Do I need to ask to go to a higher court or a higher court look at this matter, or?
I mean, you certainly can. You can do anything you want to in life until someone says no, right? But I don't know where you're gonna get. I mean, appellate courts need jobs too. How far are you gonna get? I don't know. How much money are you gonna waste? I don't know. A true and complete certified copy of all oaths, commissions, as well as bonds of all officers of the court, including but not limited to deputies, court clerks, judges, magistrates, pro tems, commissioners that have or may decide to involve themselves in this matter, appointed or elected, signed under penalty or perjury on and for the official public record.
State is opposed.
Well, I don't know what bonds you're talking about. What bonds? Like James bonds?
Appearance bonds, bid bonds,
Which ones?
appearance bond, bid bonds.
I'm not familiar with that.
Stuff to that.
Political affiliation of any and all states, witnesses, and all officers of the courts. Well, I can't.
State is opposed.
I mean, I really. Any evidence which in any way is exculpatory to the case? Yes.
Anything in state's possession, I'm unopposed to. I will produce anything exculpatory that's in our possession, but regarding the case.
Number 8, documented proof of claim of injury signed under penalties of perjury with all immunities waived from the judges of this court, attorneys of record, the Harris County Superior Court, State of Texas, County of Harris, as well as this court, and for the official record. Documented proof of claim of injury signed under penalties of perjury. So what are you referring to there?
Or the opposing party who made the complaint
What?
against me, whoever made the complaint against me, who's the opposing party.
Okay, well, the Harris County District Attorney's Office.
Party that they have to complain, who's the, I don't recognize who that is.
What do you mean you don't recognize?
Said the state of Texas or Harris County's, what was that?
Right, so they alleged that you did something unlawful. As a result, the officer arrested you and then brought that information all to the Harris County District Attorney's Office. And then they, in a two-pronged matter, number 1, I found probable cause in this case, and then a grand jury indicted you on your felony case. So it's the Harris County.
I haven't been indicted on that. I just came from upstairs. I haven't been indicted on that case yet.
Has it been indicted or no? Well, I mean, they have, I think, up to 180 days to indict you, but
Correct. Has not been done.
not been indicted yet, okay. I mean, I guess, would it be the information is that he's asking for? That you want the charging instrument, I guess, is what you want.
Your Honor, again, I think it's just a
I know that it's,
actual misunderstanding, but if it were rephrased correctly, I can better understand what is being asked. And therefore, that's why I cannot agree to this order, because
I get it, but I'm
It
trying to
just
go through it with him
doesn't
so that he
align.
understands.
if it
He's
aligns
asking.
with if it aligns with something I can understand, sure. I mean, I can understand what's being asked and then I can turn it over, but I don't have that. This is not that.
Yeah, there's a lot of stuff here, you know, I'm,
Yeah, I don't know what's not being understood mostly. Like,
here, let's go through number 13, just because there's a lot here that you got 16 and it's already 130. The CUSIP number tied to this case, which will show that this court and or officers of the court are profiting off this case and it is trading on the stock market, on and for the official public record.
I mean, I am the trustee for the name Eton Ematon. Birth certificate's right here. Administrator and the beneficiary for their name. I've been the trustee. I have all my paperwork that I need to prove to the court. I mean,
And
that's
that
where I
may
made the
well be
trial.
good for federal stuff, but not for us. This is state.
Not familiar with a lot of statutes, so yeah.
A copy of all officers of the court registration report and profile, which is registered under Dunn and Bradstreet on and for the official public record. Yeah, you're gonna have to go through this motion more. It needs to be more specific. I'm, you know,
Point just for the record's purposes, to say as opposed to this motion in its entirety at this time.
so not 1 and 7 then.
Not with immediate, not that language.
Oh, right.
And we
Okay.
cannot modify that.
So it needs to be more specific. You need to have a more like realistic guideline. They can't give you stuff immediate because he may not even have it in his possession. So I can't order him to give you something that he doesn't have in his possession.
How soon can they get, next trial date, my next court date, will they have it, or how soon?
I don't even know. I mean,
Body cam and dash, I can escalate that by the next court date. The lab, I am unsure of a timeline at this time. The lab of the
Marijuana.
substance.
okay. And I'm
So-
gonna tell you now, it takes a lot. It takes quite a while to get labs done because, I mean, you imagine, we live in a city with 4 million people. Do you know how many people get arrested with alleged illegal substances that have to be tested? You get in line in front of everybody
I
else.
do have the lab results from the store that I got it from. I have the store that is, and the lab result papers that they got it from in Houston, so I could submit that as well if it makes it quicker.
I mean,
I know y'all still have to do your
I know
own.
that you're saying that, but remember, there's always two sides to the story.
True.
So they need to test what they have to see what that is. And it's going to take a while, but it'll get done. You just be patient, but it'll get done.
At this point, we are pending body cam dash in the lab. That is what
Okay.
discovery is pending.
Typically what we do is we'll set it out 30 days and then we'll just have you come back. And when you come back in 30 days, we'll see where they are. And then at that time, you guys can make a plan to go over the evidence. And you're not going to give him a copy though. He's just going to have to review it.
I believe it's subject to inspection.
Right. So you're going to have to come, bring a computer.
USB.
It's not through VHS, it's through,
I'm unaware. I'll familiarize myself more before the next court date of the transfer of.
you're going to probably need to bring yourself a computer that has a CD-ROM because usually they have stuff on CD-ROM drives or on CDs so that you're going to have to be able to look at it. Any kind of dash cam, any kind of body cam, they usually put it on a CD-ROM or on a CD for you to be able to look at it. The only other thing I need you to do is I need you to swear to us that you're not going to drive. I am making it a condition of your bond.
I hold that until.
No.
But all this, some stuff in my paperwork. I don't drive, I
No.
don't go by
No.
driver's license.
No.
I have my passport that I do go by.
Nope. I need you to do it now. Okay, I need you to do it. And I'm making it a condition of your bond that you sign the document that you're not going to drive,
I don't want to
convey.
contract or consent to anything or agreement to anything like that because I'm still trying to see
I'm going to revoke your bond. If you don't sign it, I'm going to revoke your bond. That's it.
I gotta be forced to sign that. If I don't sign it, I can't have the option to take that
Oh,
paper.
no, I'm not, you don't have to sign it, but I'm going to revoke your bond.
But in what matter of that,
Sorry,
I don't understand why my bond will get revoked because of that.
because I am ordering you as a condition of your bond not to drive, convey, travel, any way you want to put it, behind the wheel of a car in Harris County, Texas, unless you are properly licensed with a Texas driver license and liability insurance in your name.
And liability on my cars, I go by my US passport now. I don't go by my Texas driver license. I don't go by licensing anymore. Not commercial.
Nevertheless, I'm having you sign a document that you understand and that you promise that you're not going to do it.
I don't understand it fully, but that's why.
If you don't, that's okay, but I am going to revoke your bond. And that's it.
being forced to sign this right now, or it's like, because
You don't have to sign it. You know the consequence. You're hearing it now. If you've never heard it before, you're hearing it now for the entirety of the case.
I mean, I could get my driver's license. to show
If you do, if you get your driver's license and show me
I'm
that
not
you
a
have,
driver, I'm not a commercial driver. I don't engage in commerce. I don't do.
do you
anything.
think that the 5-year-old kid that gets hit and killed in a car, or the 69-year-old grandmother that ends up paralyzed from an accident cares whether you were conveying, whether you were in commerce, non-commerce? Injuries don't care whether you're conveying, whether you're traveling. Accidents happen whether you're conveying, whether you're driving, whether you're traveling. That doesn't care, right? When you get into an accident, it doesn't matter in what method you're doing it. An accident is just that. And if you have an accident, I want to make sure that the other party will be taken care of. I'm only asking you to follow the law. I'm not asking you to split the atom here. Great.
Break the law or any of that, but
Great.
I don't
I'm
engage
asking you
in
to sign this. If you don't have to, but I'm going to revoke your bond. That's it. And Mr. Emiton, if you get a Texas driver's license and you get insurance, I won't take this deal off.
That's what I believe in, and that's believe the Constitution. I don't, was it,
That's okay.
they trying to apply that I need to get a license and insurance when I used to be a commercial driver for this day. I don't commercial drive anymore. I don't do medical transportation. I'm just a.
Did you hear what I said about an accident, about whether you're
I
conveying or
understand
traveling?
exactly what you mean about the accident.
Okay,
I know if I was to get on the accident road with no insurance, I could get sued and it'll be a civil matter and I go to jail. I understand that. That's why I travel very cautious. I don't.
you just said I drive.
I'm saying I
I
travel
drive.
very
You
cautious.
said the magic words.
I was a driver.
Come on, don't be Helen Keller. Come on. And I'm trying to protect all of Harris County.
I'm not an
You're
engineer.
protecting you. I'm protecting all the 4.2 million people here. That's what I'm doing. Because if you get into an accident, I know that you're not going to be out a dime out of your pocket. But all those other people, they're going to be out a crap load of money. And I'm going to do everything in my power to protect every single person of Harris County. And I don't care if I offend you. I don't care if I make you mad. I don't care if your sensibilities are upset. Don't care. I don't. All I want is every person protected. And that's it. And I'm doing what the law requires. I'm not asking you to do anything that's not outside the law. And you, as acting as a lawyer, should be able to look it up and see, because it's all in the transportation code. So you can sign it. If you don't, I'll have you meet with Stephen. That's it.
I just want my rights reserved.
They're reserved.
I'm waiving my rights to the court.
No.
Signing that's waiving my rights. It's a contract. It's me.
What right are you waiving?
My right to travel. That's infringing my right to travel with the Constitution.
No,
I wanna protect
no.
the rights of
Take the
14
Dodge Patas.
14th, I don't know what that means.
Happy trails. Use your feet. You can travel with your feet.
I can't, but I live in Austin. I don't live here in Houston.
Take a bus. Take an Uber. But I want to make sure if you're caught driving, I'm going to put you in jail and I'm going to make your bond so high you will spontaneously combust, because I want you to understand that I mean business and I'm protecting every single person I can. And that's it.
The court forced me to sign this right now.
No.
I mean, threaten me with jail or arrest if I don't sign this. Right now.
Correct. That is correct.
I'm in
That's correct.
imprisonment if I don't sign this. This is on the record.
It's on a record. I have a reporter right here and it's on video. Mr. Emiton. So we're going to make you a copy and then you can go on your way. Just be careful. You made a copy.
That's a copy of it.
Okay. Just be careful. Don't pick up any new cases. Get a license, get the insurance, come back, and then we'll let you drive. Okay? All right, bud. still good enough for me. So I'm gonna put here, you swore him to this, right?
No. I just need the copy.
Come on, Melissa.
Judge, you want to go over the docket?
Yeah, come on.
Page 1.
2501.
Page 11. Martinez, rearranged that left.
2501.
Judge, that was it.
That's it. All right, guys. Yeah, sorry, one more. Hey, I want you to know that even though you signed this, is that an E? Are you still on the record? Can you go on real quick? Just real quick. Is this say EZ?
Hold on. Okay, Judge, go ahead.
Okay, so we're back on the record in 2522688. I had Mr. Emitom sign an affidavit promising us he's not going to drive, travel, convey in a car. And he signed it as, it says EC, is that right?
ECE.
ECE / all rights reserved, UCC 1-103. Is that your signature?
Yes.
Okay, I'm still gonna hold you to this if I find that you drive. And I'm gonna tell you now, you will end up going to jail. Do you understand?
Yes, I just want to reserve my rights. That's all.
Understand, I'm gonna hold you to it if I catch you driving. It's gonna go sideways real quick. Okay, good. All right.
Raise your right hand. Do you swear that you will not drive any motor vehicle without the court approval? Yes. Okay.
Done.
Can y'all subpoena the cameras?
You can do whatever you want. You're going from here to here to here to here to here. Listen to what I'm saying and focus on this in the now. Don't start thinking of something in the future or something because you're not listening to what's happening now. I'll give you an example. I got pulled over months ago. I know I was in the right, but the officer came up and he goes, "Why did you stop? Why didn't you stop at that stop sign?" I know I stopped, may have been for a second or two. I told the officer, "Listen,
Invoke my constitutional amendment rights as well as my civil and civil rights.
Computer remains silent. Yes, sir. No, sir.
is there a problem?"
I honestly feel threatened by this courtroom.
And this is not the circus. This is not a playroom. This is a court.
I'm very coherent and competent.
No one says you were incompetent, but you have bond conditions that you're supposed to live up to. And we've given you so much as we've also given you a lawyer, and you're supposed to treat everyone here with respect. And when you don't, there's serious consequences.
Is there a thing for self-representation? I know that is a third option as well.
Of course you can represent yourself. You can do open heart surgery on yourself too?
Well, I ask for fair representation in a speedy trial.
No one here does anything to hurt anyone. The only thing that we're concerned about here is public safety and that everybody gets treated fairly and with respect. That includes
Life and safety against Harris County.
I don't know what to tell you about there, but you need to take that with whoever you feel threatened by. But
Harris County.
Here, we need to protect everybody in Harris County.
Me and my children.
We've given you a lawyer. I want you to treat him with respect. And I want you to treat our clerks with respect, our bailiffs, and us. I'm not asking for much. The only condition I put on you now is to not go back to the location where you were allegedly trespassed from. They don't want you there. So that's why I'm telling you now, don't go back. That's the only condition that we have.
In regards to my housing, which is my documentation right here, that should be submitted into my file. My stuff is supposed to be terminated on the 30th of this month, which I had probable cause to actually go and speak with Gary Baxter in regards to my housing contract. I also emailed informal hearing before November the 1st and haven't got a response back. So I had every reason to be at Houston Housing Authority.
You may have had a right to be there, but at some point, they're well within their right to say, look, we don't want you here anymore. You are creating a disturbance, so we would like you to leave.
Can y'all subpoena the cameras?
You can do whatever you want. You're going from here to here to here to here to here. Listen to what I'm saying and focus on this in the now. Don't start thinking of something in the future or something because you're not listening to what's happening now. You may have had a right to be there, but at some point you lost that because of the way you may have treated everyone and they didn't want you there anymore.
I'd like to file a hate crime against Harris County, the city of Houston.
Okay. You hear what I just said?
Hmm?
What did I just say?
Oh, I can't go back to 2640 Fountain View Drive in regards to it being my property, but have an actual,
I believe so. It's the Houston Housing.
yeah, the Houston Housing Authority have an actual reasons to be
That's
there.
not to say you may send them an email. You could send them a fax. I don't know if that would include calling. As far as trespassing is concerned,
I can look into it, Judge. I'm not sure.
Yeah, I was wrongfully
they can
evicted.
have an issue if she calls over there. That I don't know.
The
Wrongfully
notice here
terminated.
that is kind of the subject of this incident does give her multiple options: email, mail, fax, phone. And she did send those emails. She was,
I don't know now with them telling her they don't want her back. How does that play into?
If they haven't asked for a no contact order and there's no specific person, I would say.
Exactly.
Because she
No response back from my
she still has
emails.
not been, she lives in, she has housing assistance through the Houston Housing Authority, Judge. And it says her assistance will be terminated on the 30th. So I mean, this is where she lives of this month. So she's still got a couple more days to try to resolve whether she gets to continue, having housing assistance.
The only other thing, it's what's your last name again?
Simmons-Irvin, Ervin.
You're very passive aggressive in the way you come off.
Oh, I'm sorry, I'm a victim of Harris County.
That may be well.
And so are my children screaming.
That may be well right. But in life, you get more with honey than you do with vinegar. And when you go to these people and you act in such a manner that they think you may be threatening them, you're not going to get far.
It's
Listen,
retaliation.
are you listening to what I'm saying? I'm trying to tell you, sometimes if you tuck your tail, you may get a lot more in life. I'll give you an example. I got pulled over months ago. I know I was in the right, but the officer came up and he goes, "Why did you stop? Why didn't you stop at that stop sign?" I know I stopped, may have been for a second or two. I told the officer, "Listen, Simmons," I told the officer, "Look, I'm sorry. It was an accident. I'm an idiot." He let me go. If I would have said to him, you a-hole, you're wrong. I didn't stop. I did what I was supposed to do. What do you think he would have done? He would have probably given me 5 tickets. But because I said, I'm sorry, I'm an idiot. It was stupid for me to do that.
Well, when you're facing reverse psychology,
you get more with honey.
and they try to provoke you.
So what? Who cares? Be the bigger person. You're still going to get more. That's life. That's maturity. And when you tuck your tail, sometimes you get so much more, even if you're in the right and they're in the wrong. Who gives? Sometimes that's what you have to do.
I also understand the indirect language it is in the Harris County Handbook dated 2021. And anybody that threatens and harass me in it, I have every right to press charges.
Did you just hear anything that I just said?
I did. I understand. I won't be there, but I know that I had every right to be. So if I'm forced out on the
You
streets.
don't have every right to
It'd be
be.
because of the
You
government.
don't have every, I am telling you now, and I'm ordering you not to go back to this place.
I'm not going there, but I have every right to speak. So I guess I need to contact Washington or somebody in regards to my contract and things, because this is a government facility. And as it says your housing assistance will be terminated on 11/30/2024. I also have two different client numbers as well. One number is 582213 and another one is 251651. So I had every right in regards to speaking with Gary Baxter again, which is right here, Kenneth Coles, Gary Baxter. I also received an email to reinstate my housing, I guess, I don't know, from Gary Baxter in regards to all that. So I'm just confused, because if I'm forced out on the streets in regards to being homeless and they're trying to pass new laws, then just so hypothetically, of course, thrown back into Harris County against my will while I was held for 6 months, which is a violation of my constitutional and amendment rights, then it's retaliation. Also, I was told to surrender my inheritance in the direct language while I was being attempted murder by Harris County.
Have you speak to Corey about everything. Just remember, be nice. You get a lot more when you're nice than when you start raising your voice and yelling.
I am a traumatized victim. So if y'all could please work with me in regards to that, because I am a victim of Harris County. I do have a vow of violence against Women's Act. It is still in the residence portal and everything. Simmons Urban.
If anyone ever treats you wrong, just tell me and I'll try to do what I can to help you out. In any way, any shape, form, fashion, whatever you know, I'll help you as much as I can. All you got to say is the word.
Also facing my children being, the child explicit cases.
Okay.
So let's just focus on just signing your
So
bond condition.
I'm going to have you sign the conditions. We'll have you stay with Corey. Just be nice. Hopefully you'll get your housing back if you're nice. That's it. All right? Please. You are Aziel Gracia.
Sir.
Mr. Gracia, so
He's charged with, I've never seen this before, Judge, but he's charged with violating a bond condition.
yeah, I've certainly seen it. It's either
It's not a protective order, it's a bond condition.
right, because they can't make the protective order case because it's been more than 61 days,
Had
right?
nothing to do with the protective order, Judge.
So yeah, right, I get it.
It was a different situation completely. Had nothing to do with family violence.
We'll get there. So you're charged in violation of a bond condition / protective order. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. If you cannot afford a lawyer be appointed to represent you. So before we start, was he in a PTI? Is that why this case is 1,000 days old?
Yes, sir. He just has a few BIP classes left to finish the PTI.
Okay. Okay, go for it.
Judge. The officer was dispatched to a business in Harris County, Texas, in response to a disturbance. Upon arrival, the officer observed the defendant grab another male aggressively, and the officer conducted a search on the defendant's person and found a loaded gun in the front pocket. The defendant is currently on bond for an assault family violence and has bond conditions in place prohibiting from possessing a firearm.
Yeah, all right. Mr. Gracia, I'm going to find that there's probable cause to go forward on the bond conditions. State, what's your position as far as he's in a PTI? He's now picked up a new case. Mr. Gracia, I want you to know that we take these bond conditions extremely serious.
Sir.
You don't, though. This is not your first VPO. This is not your first violation of bond condition. You don't get it. No means no. Doesn't mean maybe. Doesn't mean I'm going to a high crime area. No means no. And now there are consequences. Stephen.
And Judge, can I tell you a little bit about the case?
Sure.
You know, just to explain to you what happened. He was at his business. He owns a trucking company. He hired somebody who he said he took a chance on him because he's has a sketchy record, convicted felon. It didn't work out within a couple of days, so he ended up firing the individual. The individual refused to leave the premises or refused to accept it. So he started threatening him. He went inside. The individual started trying to damage the trucks. So at that point, he was fearful. He went and retrieved a firearm that he knew was hidden in the vehicle. I'm sorry, in there. I understand, Judge.
It's about the worst thing that you can do. Imagine if you use the firearm. Who gets charged with murder? Mr. Gracia? Who has now dug themselves into a potential 50-year hole? We have a case like that today where a meager argument, someone who's charged with assault is now charged with murder because of a silly ass, stupid ass argument. Now, dude is sitting in custody with a $250,000.
And he's been punished at this point, Judge. He's been punished for violating the bond by getting an entire new case on that. So as far as him going into custody for violating the bond condition, I would hope that you would take that into consideration, the fact that he has gotten punished on the bond violation already, and the fact that he's already had to hire a new attorney for two cases at this point, and it's probably going to affect the other case. So I would hope that you would continue supervision on that, just taking that into consideration.
I truly appreciate your position, but you have an assault from 2019 of a family member. The following year, you pick up a violation of a protective order or bond condition. Now you have another assault that they were even, what the hell you're looking over there? Was it Jesus over there? You already have an assault of a family member that was dismissed as it is. You were lucky enough to even have this kind of an agreement where they're willing to dismiss a second assault of a family member. And now you pick up another violation of a bond condition. Eric, he doesn't get it.
I understand, Judge.
You don't get it. And now I have to show you, we mean business. I think that you are in utter and complete danger to public safety. And I will do everything in my power to protect my public in every single way. Because the last thing I want is you to pick up a murder case like we have here this morning. Someone else goes with you.
Judge, one more thing. There's a bond condition on there that he's not allowed to return to that address. That address is his business. It's his place of business. The other person has no right to that address. So he hasn't worked for the last week and a half because there's a bond condition, I'm assuming from the magistrate, that doesn't allow him to go back to that business.
Show me proof.
I'd like to be
Show
able
me
to take
proof. And, the proper, and you need to advise, the proper way to do things is you call the cops.
I get it, Judge.
Really. I mean, that's, if you own the business, you show it. I mean, how easy would it have been to just call police?
I mean, he has a right to defend his property and
Not while the case is open. He does, but not in that manner.
It's one of those things where things happen quick and you have to make a decision. When we're talking about trucks that are worth hundreds of thousands of dollars and things like that.
911, man. Really?
I mean, how long do they take to get there, Judge? So
Okay. They will still take his ass to jail and then, try to get restitution or whatnot. But
So as far as the bond goes, can you set him a bond today?
Of course.
And Judge, we've contacted Conrad because it's his case, but I just want to confirm that bond has been revoked for his prior case. Is that correct?
yeah,
Okay.
yeah. On the assault, I'm revoking it.
Yes, Judge.
Looks like they set the bond at 20,000 on the new case.
Yes, Judge.
I'm gonna mirror it.
Because he's already posted that bond. He's already hired me. He hired me on the other case as well. There's a motion to sub in your queue that I need you to sign as well.
I'll sign it for you.
I'd ask that you set that new bond at $500. It's tough for the family, Judge. I mean, at this point, he hasn't worked in 2 weeks. He's trying to get back on his feet. He did everything properly. He didn't go back to the location because of the bond condition.
I'm not doing $500. I mean, I was thinking that was going to mirror the same one. I was put it at
And that would be his
20,000.
next position to mirror.
So he understands that we mean business. If he's unable to bond out, I'm always willing to talk after a couple days. But I want him to understand that we take it absolutely serious. And when you go over there with a gun with the intent to do some serious damage, hell no, no way, no. And I think that making it 20,000, what the other one is, hopefully it'll get his attention.
Okay, would you
But like I
consider
said, look,
10,000?
like I'm not out for blood, Eric. So if he's unable to, after some time, come back, and I'm not talking weeks, but, a couple days, so he realizes that we mean business.
Holidays. So we're talking about 2 weeks minimum. So would you consider giving 10,000?
Well, remember, I Zoom. So you can be in Abu Dhabi. I'm still, here.
His mom's present, so let me talk to her.
Yeah, for sure.
Sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pretrial over there, and they said that I have a 45-day miss.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock, and I still did the ones later on when I would wake up, and they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one
I started
pass after the other. He goes with you.
I'm here on behalf of Mr. Naylor this morning with Mr. Jones, Your Honor.
Come up, Mr. Jones.
Mr. Naylor is in Cancun until Monday of next week, Judge, so he's not available this morning.
I
So
understand.
I'm kind of filling in. I have had a chance to look at this violation report regarding missed blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
It says 19, Your Honor. That's 7, within that 7 or 8. But Judge, I would ask if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So that he can
I'm
be-
sorry, Ben, I can't. I have to know, you have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all. Cold weather. I apologize. So can I please speak on the breathalyzer?
No.
Just
You
told me
know
last
what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here and instead you're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Oh, please, no.
No.
And
It's you.
but to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate and, for
I
alcohol.
go to sleep early.
Test. And he is blowing outside the window, so we don't know what he's doing.
Oh my God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pretrial over there, and they said that I have a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor. I will do anything. I'll even go on that drug ankle monitor. I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor. It's just I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock, and I still did the ones later on when I would wake up, and they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one pass after the other. He goes with you. No.
Oh my God.
Your Honor, may we discuss setting a new bond?
Of course.
Oh my gosh. Why? Please, I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I will now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. he has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge, for
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't, but fine. Because, all right, 7502.
Visit PC, Your Honor. I have some questions.
Oh, you picked up a new case. I'm sorry, I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Yeah, him. Picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case, specifically an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading, and now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess.
I understand.
That we literally had one after the other, like a rung on a step ladder. One after the other. So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate it, Your Honor.
Sure.
But be that as it may.
I'm not going to I've never will hold anything against him. So let's go.
On December 3rd, 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was located.
What?
They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
But he has an open ag assault somewhere else too?
In Fort Bend County, Judge.
My understanding is it's an older case.
At that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done. Is it a resisting? Maybe,
So,
but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. Like, and they're,
I understand
and
that.
they're a 0.1 mile away from the location
So-
for what?
Well, okay, I get that, but so we have what we have. We've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have,
Okay.
right, Mr. Zenon? There's always two sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
No, it's the aggravated assault, but Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes blank like this for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it. Because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you, all right, hold on. Let's pull up the code.
Intake could have taken some other things, but.
Well, certainly they could have
Okay.
taken a whole myriad of, I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on, you know?
But they didn't hit. They took the one that I do not believe applies here.
Let's read the code. Okay. Let's see what the code says, because you know there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can. It's 3815. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, so I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
okay,
with
so
that.
that the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute. That's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean.
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1 miles away.
Felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like, and that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing.
Mhm.
I mean, that's what they were investigating.
And the witnesses all described.
They put him,
the
I guess,
defendant.
did they put him under arrest at the time when he said that he was making that threat?
And with being.
I mean, did they have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening that he would slap Miss Clark.
And it's at that point they start to put him under arrest?
At that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist.
it-
That's not
it
interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate with, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. It's if the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
Well, I mean, it's
okay. Well, I mean, but so
I mean, we don't know. I mean,
okay. I'm just saying.
If he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also don't have the offense report yet.
I don't care. I mean, but I think that there's enough. He's under. He places him in custody, right? He's going to arrest him. Starts putting him in the car, and dude goes plank.
I know, but I don't have the video.
I've
mean, I
shared the
think that-
videos with
Remember,
You're right, I haven't had a chance.
guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt. Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you're disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go in there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay. Well, I got to say.
3 times to search me.
Can I have a moment to look at the video? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find, if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, okay, it looks like they didn't give him a PR bond on this.
Okay. Well, then
The bond right now is set at 2,500.
Okay.
Your bond upstairs is set at 5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because it looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend Judge and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set tomorrow, Monday?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want. Surely. Do you have it?
We have the camera, the body cam.
I just shared.
Okay, so
They shared it, they just shared it with me.
Let's roll it to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Yeah, okay. Mr. Fritter, look at me. Can you imagine what life is like when someone has to walk on eggshells because they have the fear that if they make someone mad in the smallest respect of having socks not in the damn drawer?
On or about September 19, 2024, an officer conducted a follow-up in regards to an assault on a family case. Upon further investigation, the officer made contact with the complaining witness, who reported that the defendant had been harassing her since September 18, 2024 by sending her videos, voicemails, and text messages containing horrible remarks, approximately 50 to 60 messages in total. In the voicemails, the defendant curses at her, asking, "Where are you? Why the fuck aren't you at work?" and calling her various names. Additionally, the complainant showed the officer text messages of the defendant telling the complaining witness, "Kill yourself and I want to watch you suffocate, and your family hates you." The complaining witness indicated that the continual harassment is making her fear him even more. Complaining witness was able to give officers the defendant's identifying information and positively identify the defendant as a person who has been harassing her.
I see that he has also picked up a felony assault against his complaining witness as well.
Yes, sir.
Okay, what happened in that one? And I'm assuming it's the same date as this one, so I'm assuming it's out of the same transaction.
I'm not sure. So it says that I don't believe so. It says that on September 18th in Harris County, officers were dispatched to an assault. The complaining witness advised that the defendant came home upset about socks not being in the closet. The defendant punched the complaining witness with a closed fist on her foot twice on her right thigh and twice on her left thigh, causing pain. The complaining witness advised that the defendant grabbed her by the arm and forcibly shoved her out of the house, throwing her on the porch. She advised that she felt pain, and she advised that this has been an ongoing issue for the past 2 years. The officers observed purple and green bruises on her arm, foot, and her legs. The bruises were green, purple, and red and of significant size.
Is there a no contact order in this case?
Judge, who's the defendant?
This is Mr. Fritter. He hasn't harassed, Mr. Fritter, let me tell you something now. You scare me. And you scare me something good. You have since 14, assault, trespass, deadly conduct, assault, DWI, forgery, and now a harassment and a felony assault.
Judge, there has been a note filed, but there is no protective order in this case.
Is there no contact in the felony case whatsoever?
I'm checking the bond conditions. It's no threatening or harassing at this time. Would ask if that be a no contact at this court, Judge.
I don't see that the rip has been.
Are you Miss Lisco?
Yes, sir.
That's Miss Lisco right there. Come up, ma'am. Come up. I'm sending you for a drug and alcohol test right now, Mr. Fritter. I want to protect you as much as I can. No one has to have this kind of treatment whatsoever for any reason. And I will do everything in my power to protect you. All I need you to do is tell me. All I need is please give me the word. Mr. Fritter, look at me. You so much. Can you imagine what life is like when someone has to walk on eggshells because they have the fear that if they make someone mad in the smallest respect of having socks not in the damn drawer? they're liable to get a beating. Can you imagine what life is like to live with that kind of fear? You're going to live it with me now, because one false move, I'm going to make your bond so high your head will spontaneously combust. But no one, and I mean no one, should have to live with that kind of fear. I'm sending you now for a drug and alcohol test because I want to know what, if anything, is in your system. And I don't know if I'm going to allow you to have contact with Miss Lisk. But if I find that you treat anyone or put anyone in fear or put anyone in harm's way, so help me, I will grow horn and tails because I will be so upset. And it will be on you. Do you understand?
Yes.
Abel.
Yes, sir.
I'm going to keep Mr. Freder so close to me that it's just ridiculous.
Yes, sir.
I'm entering what's called a magistrate's order for emergency protection. This is a court order that identifies her as a protected individual. You're not to have any kind of communication whatsoever. You're not supposed to have any, you will not have any threatening or harassing contact. What is threatening or harassing doesn't matter what you think is threatening or harassing. It's what she perceives. So if I go like this, is that threatening or harassing? It most certainly is. And it's enough for me to put you in jail and make your bond $150,000, maybe 50, maybe 20. But I will do, Mr. Freder, I will do everything in my power to protect every single person of this county. And I don't care if you're kicking, screaming, crying because you go to jail and don't have anyone to bond you out.
Your husband and wife of 10 years. This is kind of difficult situation that we live together.
I want to protect you, ma'am. And you know, the problem is that now that he's picked up these two cases, times will be just even more stressful. We have these protective orders. They're basically like cooling off motions so that, you know, you can separate, enough time will pass. People can kind of cool down, you know, so they're not under the stress of the excitement and then unleash on you. The last thing I want is for you to suffer any kind of harm whatsoever, you know, and I that's all I want. You know, all I'm asking is how things should be normal. Like, I'm not asking him for him to do Pythagoras theorem here. So, I don't know. You know, what I'd like is if you please just talk to our DAs here. But I'd like you to have their phone number at the minimum so that should anything ever whatsoever, all you have to do is let us know. And then
I have been in contact with the DAs, or should it not be assault?
I'm here for you. And I want to make sure that you're okay. You know, I've given him a lawyer. He knows what's expected of him. And I'm going to drug test him like crazy to make sure that he's not using alcohol or dope. In fact, I mean, I'm going to test him 2 times a week. I mean, I'm setting him now because I want to know what, if anything, is in his system. And then we'll go from there.
Judge, he will come back positive, but that's prior use from.
What were you going to test positive for, Mr. Freder?
Marijuana.
Okay.
And ketamine, and probably some other stuff that could have been in the ketamine. But I mean, straight up, that's probably it.
Mr. Freder, I'm going to test you. These are your bond conditions that are going to apply to you now. And if you fail to live up to these bond conditions, I'm just gonna let you know. That's it. You will appear to me here 2 times a week to take drug tests. And if I find anything is in your system, and I don't care what it is, I'm gonna lock you up. You're ordered not to use any kind of dope or alcohol. And if you can't get this monkey off your back, because I am now giving you the opportunity to do it on your own. If you're incapable of doing it on your own, then I'm gonna do it for you. Do you understand? No dope, no alcohol. And when I mean no alcohol, I mean no alcohol from any source. No isopropyl alcohol, cakes, candies, foods, gums, energy drinks, tequila lollipops, hair dye. I've heard it all, and I don't care. You come to me test positive, you'll stay with me. I also want you 3 times a week to do anger management classes so that we can deal with the anger issues. Look at me. 3 times a week. And I want a piece of paper showing me that you've done it, the date, time, location of where you've done it, so that I can verify that you've done it. And if you don't do it, you will stay with me. You now have the opportunity to address these things on your own. If you don't, you will be doing it with me. And if I get one, and I mean one breath that she's been mistreated in any way, shape, or fashion, holy freaking moly. And then, ma'am, if you'd be so kind, please, I'll have you speak to them here momentarily. Rachel, this is my card. If you ever need anything, all you have to do is get in contact with me. And I'm here for you. Whatever you need, anytime, day or night. I don't care.
All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
But he has an open ag assault somewhere else too?
In Fort Bend County, Judge.
My understanding is it's an older case.
At that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're 0.1 mile away from the location. So for what?
Please. Who do we have here, Greg?
This is Mr. Zenon, Your Honor.
Visit PC, Your Honor. I have some questions.
Oh, you picked up a new case. I'm sorry, I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Yeah, him. Picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case, specifically an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess.
I understand.
That we literally had one after the other like a rung on a step ladder. One after the other. So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may,
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd, 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed
located.
what?
They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant pushed a complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
He has an open ag assault somewhere else too?
In Fort Bend County, Judge.
my understanding is it's an older case.
At that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going plank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're a mile, 0.1 mile away from the location. For what?
Well, okay, I get that. But so we have what we have. We've got a disturbance at HEB. Cops go there, they start to talk to him, and I guess at that point says, hey man, I'm going to slap her. So at that point, I mean, that's what we have, right? Mr. Zenon, there's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
No, it's the aggravated assault. But Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes plank like this for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because I mean, there's no better way. Let's read it.
Hold on.
I'll give you. All right. Let's pull up the code.
Intake could have taken some other things, but
well, certainly they could have taken a whole myriad of. I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on. You know.
But they didn't hit. They took the one that I do not believe applies here.
Let's read the code. Okay. Let's see what the code says, because you know there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can. It's 3815. right. It could have been like a resisting, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, so I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is.
Okay, so the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute. That's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean...
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1 miles away.
Felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay, Judge. They were investigating the assault, Judge, or the threat that he admitted to making. So it was an active investigation. And then when they were detaining him, he was resisting arrest, is what it seems like. And that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing.
Mm-hmm.
I mean, that's what they were investigating.
And the witnesses all described
I guess, did they put him under arrest at the time when he said that he was making that threat?
And with being
I mean, did they have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap the misclaim.
And it's at that point they start to put him under arrest?
At that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
remember,
that's that's not interference with public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. The officer didn't put in the report. He's not saying in the dim summary, you are under arrest.
Well, I mean, it's...
Okay, well, I mean, but
we don't know. I mean...
Okay, I'm just saying...
Well, he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is...
We also don't have the offense report yet, Judge.
I don't care. I mean, but I think that there's enough, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
I know, but I don't have the details.
I've shared the videos with
remember,
right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you are disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I gotta say.
3 times to search me.
Can I have a moment to look at the video? You know, he's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find, you know, if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, you know. Okay, it looks like they didn't give him a PR bond on this.
Okay, so well,
the bond right now is set at 2,500.
Okay.
Your bond upstairs is set at 5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because it looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You know, you got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, you know, and I don't know what we need to do to get your attention, man. Just in life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, you know, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend Judge and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set tomorrow, Monday? What in?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want, surely. Do you have it?
We have the camera, the body camera.
I just shared.
Okay, so
They shared it. They just shared it.
Let's roll it to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Yeah. Okay. All right, Mrs. Zenon.
Okay.
See you tomorrow.
See you tomorrow. Probably gonna agree to disagree here. But I would like for you to watch like the 2 minutes of the video that I think.
So Judge, I also, because you had this question yesterday, I called Fort Bend and they confirmed it. The Fort Bend County aggravated assault with a deadly weapon. It's just sealed, and that's why I didn't pop up.
It's just what?
It's sealed at the moment.
Sealed. Is it a new case? Is it an old
It was
case?
just filed in November, Judge.
Wow.
But the offense date was in March.
Okay, so that's what I'm asking. It was the offense date was March of 24.
Yes.
So it was allegedly committed prior to. Now, nevertheless, it's still a warrant.
It was.
But how on earth has it never been?
It's because, so they'll unseal it whenever an arrest happens, Judge. The case was filed. He had 2 other charges in this county, even that he caught even after that one.
I'm so confused. You know that Fort Bend knows that there's a felony warrant, a dangerous felony warrant, and they failed to execute that warrant over and over. He's been on probation. He's been meeting with his
dating in here that he's got on 2 years probation for, and then had also a UCW here that he caught after that, and another assault of a pregnant person that he caught here after that, and then another UCW that he caught here after that. So he had just a string of cases, and I mean, the list goes on. But there was just a string of cases that he caught even after that. So I guess they just never, I don't know.
I will tell you the shenanigans from my experience that Fort Bend does. So if they think they're going to TDC, I have seen them let them go to TDC, wait till they even make parole or discharge or finish that sentence, right? and then they're out and they go, oh, now we're gonna file you. And then parole goes, oh, now we're gonna revoke your parole. Those are the shenanigans that I've seen.
Judge,
And this has been going on for years out there, like prior administration continued.
But I mean, I guess ultimately at the end of the day, even if that happens, like, let's just say the parole board's going to look and see that was like extremely old, right? I would have think. So, first time he failed.
I'm not gonna read it. It doesn't matter.
As in,
I mean, it doesn't matter. It's on video. It doesn't matter.
No. Okay. Parents required, but you know.
Correct.
If he pays.
On video, guys. Like, I watched it. I'm not crazy. Like, this, it's on video.
Sorry to keep you
Let's
waiting.
talk to Judge about it.
You're still upset?
Yes, I watched the video and I'm even more upset, Judge.
So Judge, we just want to address some of the questions that defense and you had yesterday. Defense was saying that he felt that interference statute was overbroad. We found case law saying that it's, or vague, that it's unconstitutionally vague. We found case law saying that it's not unconstitutionally vague. It's from DeContal versus State. I've tendered it to defense. Can I approach
Sure.
Judge?
I gotta imagine that if it was unconstitutionally vague, someone would have challenged it and it would have,
Well, maybe I haven't had my case yet.
Okay.
And, I'm happy for you to make new law, always.
Judge, did I hand you DeContal versus State? I did. Just.
The Cantel.
Yes.
Yeah. Oh, look, it's out of Court 8 in Harris County.
That's from this case. Yeah.
So why are you saying that there's no PC in this case?
Is there a PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. So they get calls for an assault, a disturbance, whatever.
You're telling me the fact that they're saying he goes plank in the car while
he doesn't
being arrested
he
doesn't
does
happen?
not go plank. It's on video, Judge.
Would they say he uses his, I guess he uses
He's in
his
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. We also watched the video.
We watched the video and we have a timestamp, Judge.
Could it be that okay, so I know that a lot of times when they're putting a defendant into the car, they need help, right? They're unable to do it by themselves, or is he actively resisting getting into the car?
He tried exiting the vehicle, Judge. And that's why they had to push him back into it.
He leans forward. He's yelling at his mom, record, called. The third time they have taken him out. This is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, well, search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't been caught. The cop's sitting there going, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking him at. DA, Officer Singh, it's a 27-minute video. Okay? At no point is the DA's office called to this point. Okay? That happens after. Fine. For an assault, they can argue. I can argue case law. Ford v. State, specific articulable facts of crime may have occurred. Fine. They are there on an assault. Okay? They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's common for officers to conduct an investigation before they call intake. That's not an abnormal thing.
I mean, that's neither here nor there. But the question is he impeding the arrest or the function of arrest? Because I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Xenon, Your Honor.
Mr. Xenon is not allowing the officer to arrest him by putting him in the car.
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car and then take his legs and place them into the car.
He was cooperative the whole time. He's on his mom. If anyone's aggressive, it's the cop from the beginning.
Judge, the
And
cop.
I asked at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge,
What? No.
we can watch the video, Judge.
Cue it up. Let's watch it. Can you put it on the screen somehow? So we can all watch?
We can just go to the back and watch it. Do you want to hook it up? I don't, because he has issues hooking his computer up to the technology.
It's not.
Yeah, it's this one.
Judge, did you want to watch the whole video or did you?
No, just the relevant portion. I don't need to see the whole thing. No, just that part that's relevant. You know, I guess if you want to just put it right there and just turn it around.
Yeah,
Just right there on the table. Yeah, right there. And set it.
I'm just turning the volume up, Judge, as well.
He talking about don't let him pull up. They talking about I got a warrant out for Fort Bend County for assault. Look, he pushing me. Mama, record me. Mama, look. Mama, look. Record him. Now you're under arrest. I'm under arrest. Yep, you charged, Bubba. Resistant transport. Resistant? I wasn't resistant. You just resisted transport. Yep.
What the hell is that?
Now you got a new charge. Yep.
Come on.
Thank you, Judge.
Really? That's it?
That's it, Your Honor.
That's the relevant portion that defense is.
Oh, come on.
The officer is investigating legitimate.
I know, but no, I'm with
Do
you.
you see why I'm so upset, Your Honor?
All right.
Okay. Thank you.
You can refile this resisting.
Yeah, look, yeah, I mean, you're not gonna hurt our feelings. You need to do what you need to do. Perhaps it was the wrong one, but yeah, was it resisting?
Nope.
My name is Bennett and I ain't in it. But no PC.
Thank you, Your Honor.
The defendant tackled the complainant to the ground and held him in a rear chokehold for approximately 10 seconds, impeding his breath. The complainant stated he felt pain and suffered minor injuries to his person, including a scrape on his left knee, a scrape on his right elbow, and a swollen upper lip. The officers detained the defendant, and a search of his person revealed 0.68 grams of meth in his right pocket.
If you have a problem with drugs and alcohol, you better address it because I'm telling you now.
No, it's not a problem, sir.
Look at me. If it becomes a problem, I'm going to address it for you. And I promise you're not going to like the way that I do it. I'm going to test you heavily. I'd like to send Mr. Rodriguez for a drug test right now, please. Stop. Don't say anything. Stop. I'm sending you for a drug test now. I'm going to have you come back. I want to see what's going on. That's it. Good morning, Mr. Rodriguez. Sir, you were charged with assault, bodily injury, and criminal mischief. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You're facing up to a year on both of those cases and or a $4,000 fine.
Judge. On December 24th, 2024, the officer was dispatched to the location and made contact with the complainant. The complainant stated that he followed the sister when she left the house to try to get her to come back. That's when the complainant ran into the defendant, the complainant's sister's ex-boyfriend, and told the defendant he could not be around his sister. The defendant walked up to the complainant really close, and the complainant pushed the defendant to get some space, and the two then began to get into a physical altercation. The complainant stated the defendant bit the complainant's left arm in between the altercation and then ran away. The complainant complained of pain and was advised by EMS to get stitches, and then the defendant was ID'd with mobile APHIS.
You said this was a sister as the complaining witness?
No, Your Honor. The sister was the ex-girlfriend of the defendant. The brother was the complainant.
Got it. Okay. Tell me about the criminal mischief.
On the criminal mischief, On December 18th, 2024, the officer was
So same day.
Same day, Your Honor. No, it was before. The assault was on the 24th, the criminal mischief was on the 18th. So on the criminal mischief on the 18th, the officer was dispatched to a residence in Harris County, Texas in regard to a disturbance. The officer made contact with the complainant who stated that the defendant broke his window with a rock. The officer made contact with a witness who stated that on the 16th, he observed the defendant throwing a rock at the front window, breaking it. The defendant was then observed by the witness leaving the area, returning to the side of the house and throwing a bigger rock at the side window, causing it to shatter while also trying to enter the home through the window. The damage to each window was approximately $1,200.
Both of these happened on the same day, right?
No, Your Honor. The assault was on the 24th, and according to the witness, the criminal mischief was on the 16th of December. So the criminal mischief occurred before the assault.
But I'm looking at the information. The information says December 16th on both.
There is a second assault, Your Honor.
What?
There's one.
On the 31st.
Yes. Oh, okay. My apologies. I was reading because he was just picked up an assault. Let me read the assault that's out of the same transaction, Your Honor, because he picked up another assault, and that was my apologies. So for the assault on the 16th, the officers were dispatched to a Walmart in regard to service for a disturbance. And the defendant was taken back to the original scene, and the officer spoke to the complainant who stated that he went looking for the defendant because he was a person of interest in a previous incident. While waiting for police to arrive, the defendant tackled the complainant to the ground and held him in a rear chokehold for approximately 10 seconds, impeding his breath. The complainant stated he felt pain and suffered minor injuries to his person, including a scrape on his left knee, a scrape on his right elbow, and a swollen upper lip. A witness, the complainant's girlfriend, witnessed the incident and saw the defendant choking the complainant. The defendant also admitted to placing the complainant in a chokehold.
All right, Mr. Rodriguez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If you have a problem with drugs and alcohol, you better address it, because I'm telling you now.
No, it's not a problem, sir.
Look at me. If it becomes a problem, I'm going to address it for you. And I promise you're not going to like the way that I do it. Do you understand? I'm going to test you heavily.
That's fine.
What's the name? What is your name, sir?
Mark.
Mark. Hi, Mark. Nice to meet you. I'd like to send Mr. Rodriguez for a drug test right now, please. Stop. Don't say anything.
I consume marijuana.
Stop. I'm sending you for a drug test now. I'm gonna have you come back. I want to see what's going on. That's it.
Okay. All right.
But come back. I'll give you a lawyer today. I want to know what's going on with you so that we're both on the same page.
I can tell you.
Don't say anything. Stop. Stop. Go take the test, and I want you to come back. I'm going to appoint your lawyer today. As far as your bond conditions are concerned, you're not to have any contact with the complaining witness in this case, not to go where they live, where they work, where they breathe. You're not to be in possession of any weapons. Do you understand? If you violate these conditions, you know what's going to happen. Do you understand? All right, please. So don't worry about conditions, because I'm going to have a monitor.
Yes,
Mr. Chong.
Judge.
5002.
I'm Christina Rodriguez. He's on today's watching.
Okay, great. Come up, sir.
And we have those results.
Great.
Judge, data presented positive for THC, amphetamine, MDMA, cocaine, and methamphetamine.
Is there something that's not, I mean, really? Stop. It's a rhetorical question, Mr. Rodriguez, but I'm going to tell you now, it stops today.
Sure.
We're going to do this the easy way, or we're going to do this the hard way. I am giving you the opportunity for you to try to do this on your own. If you are incapable, then you're going to stay with me and we will do it the hard way. Do you understand?
Yes, Your Honor.
You will be required to test bi-weekly here with me so I know that you're not using.
Yes,
And
Your
if you show me that you can stay clean, then I will stop. But we will do this in baby steps. But for the time being, you're going to stay here and test a lot with me. Do you understand? I will give you a pass of 45 days on the THC, 45 to 50 days on the THC.
Yes, Your Honor.
But if after that time you continue to test positive for marijuana,
Yes, Your Honor.
I have given you a lawyer. It is your responsibility to stay in touch with Anna. If Anna tells me she can't get a hold of you because you play games, likewise, the bond will go bye-bye.
Yes, Your Honor.
All right? Okay?
Thank you, Judge. We'll see you on
All right,
Monday.
Mr. Rodriguez, see you Monday.
Yes, Your Honor.
Thank you. Can we be excused?
Good morning, sir. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 18th, 2024, the officer was dispatched to a disturbance at a residence in Harris County, Texas, and the officer met with the defendant and complainant, who are members of the same household. The officer observed no visible injuries, and the complainant stated she had been living with the defendant for 7 months. The complainant stated they were arguing in the morning, and the defendant pulled her by her legs off the couch. Complainant stated she hit her head on the coffee table as a result of the defendant pulling her off the couch, causing her to feel pain. The defendant stated the complainant had been evicted and he let her stay with him. And the defendant stated the complainant said something disrespectful, so he pulled her off the couch, but not hard enough to hurt her. The defendant said the complainant then started hitting him and he was blocking hits to defend himself.
Okay. Mr. Whittington, I'm going to find that there's probable cause to go forward with the case. Do we know whether she wants to have contact with him or no?
A rip was attempted, but there is no contact yet with the complainant.
All right. Until I know that she wants to have contact with you, I'm ordering you not to have contact with her. Do you understand?
Yes.
A protective order has been issued in this case. I would get to know it. If you violate this protective order, the state can and probably will file additional cases against you, including a violation of protective order, which is one of the worst cases you can pick up. Just don't have any contact with her and everything will be fine. Do not pick up a new case. Do you understand?
I understand.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Ramona, sign a reset, and then after that, you're on your way. All right? Please, sir. Good morning, sir. Sir, you're charged with assault of a family member. Your case is 662 days old. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 5th, 2023, officer dispatched to a residence in Harris County, Texas, and met with the complainant, who said she had been dating the defendant for 4 years. The complainant stated the defendant had been drinking a lot and noticed his driving was unusual and told the defendant multiple times to switch so she could drive. The complainant and the defendant switched, and while she was driving, they got into a verbal argument, and the defendant hit the complainant on the right side of her face, causing pain. Once they arrived home, they got into another argument, and the defendant started throwing the complainant's clothing and belongings out of the window of their apartment. The witness was in the car with the complainant and saw the defendant hit the complainant on the back of the head or on with the back of his left hand on the right side of her face 1 time.
Okay. I'd like to redo the protective order. Listen, one was already entered. Do we need them to do a new one? Mr. Harris, I'm entering in what's called a magistrate's order for emergency protection that identifies the complaining witness in this case. She is now a protected individual. You cannot communicate. You cannot do any family violence, assault, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon, go within 200 feet of where she lives or where she works. Do you understand? If you violate this protective order, the state can and probably will file a violation of protective order, and it's one of the worst cases you can pick up. Before you leave, you need to get to know this protective order so you don't violate it. I am ordering you not to have any contact with this person and not to be in possession of weapons throughout the remainder of this case. Do you have a lawyer today? We're giving you one today to figure out what's going to happen with this case. Your case is 662 days old, and we set cases for trial at 180. So we're going to figure out what happens with this case. I'm gonna have you, well, for now, we'll just have you take a seat in the jury box. If you can reach out to the Mac, please. Good morning, sir. Sir, you were charged with driving while intoxicated, first offense. It's elevated to a Class A misdemeanor because of the high blow, so you were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 18th, 2024, the officer was dispatched to 3000 Southwest Freeway in Harris County, Texas, in regards to the defendant's motor vehicle hitting another motor vehicle and keep going. The caller stated the defendant's motor vehicle's tire fell off and that the motor vehicle was at a strip center parking lot. The officer observed the defendant's motor vehicle facing the Southwest Freeway frontage road and partially on the curb, leaned against the hedge. The officer observed the engine running, the defendant's vehicle in drive, and the left front tire shredded. The officer further observed the defendant sleeping, slumped over the steering wheel, and a strong odor of an alcoholic beverage, bloodshot eyes, slurred speech, and the defendant, upon waking, had poor balance requiring the officer's assistance. The defendant stated he consumed 2 mimosa beverages and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 4 out of 4. The defendant was read the DIC and consented to breath. The results were 0.169 and 0.162.
Got it. Any prior DWIs and
No, Your Honor.
license? Okay. I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're using, I'll put you in jail and I'm going to revoke your bond. Do you understand? What do you do for a living, sir?
I currently don't work. I got assaulted recently. I lost my job.
Where were you working? What were you doing?
I was a Uber and I worked
Why stop? You still need money. How are you getting money?
I had to do it through light recovery. They laid me off.
Okay. Did you want to apply for an appointed lawyer, sir? You're going to go hire a lawyer.
I can't afford one. I need a.
That's what I'm asking you. Did you want to apply for an appointed lawyer?
But I will. No, I'm not.
Do you want to?
Yeah.
Okay. If you mind, I'm going to give you an application. I need you to fill it out. I need you to fill it out in its entirety. I need everything. I need to know everything about you. I'll take a look. If you qualify, I'll provide you with a lawyer today. Does he have you said he has a Texas driver license, right?
He's an eligible license driver.
If you don't have liability insurance, then you're not allowed to drive. That's car insurance. If you don't have it, don't drive. I'm making that a condition of your bond. You must have a valid Texas driver license and liability insurance in your name. Do you understand? Okay, I'll have you fill out the application, Steve, and I'll have you sign a reset, and then we'll have you take a seat in the jury box. No alcohol, no dope. After you're done with that, you'll meet with pretrial services, so they'll go over your bond conditions, all right? Good morning. Sir, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, yes. On December 16th, 2024, at approximately 12:48 a.m., officers were dispatched to a major crash at the 6100 block of Richmond Street in Harris County, Texas. Upon arrival, the officer made contact with the other officers who had advised that when they arrived on the scene, the defendant, the sole occupant of the motor vehicle, had crashed into the ditch. Upon contact with the defendant, the officer observed bloodshot, watery eyes, slurred speech, and a strong odor of an alcoholic beverage. An inventory search of the vehicle revealed 1 bottle of whiskey under the front passenger seat, which was 2/3 empty. Standard field sobriety tests were attempted. HGN 6 out of 6. The walk and turn was refused, and 4 out of 4 on the one leg stand. The DIC was read, but the defendant refused. A blood search warrant was signed and executed.
Can you run his criminal history, please? I'd like to see if he has any other DWIs.
Your Honor, there's no prior DWIs.
Is there an allegation that he was allegedly consuming alcohol while he's driving?
No, Your Honor, they only found a bottle under the passenger seat, not cold with touch or anything like that.
Mr. Nesbitt, I'm going to find that there's probable cause to go forward with your case. Have you run his license to see if he has a Texas driver license?
It's eligible, Your Honor.
All right. I'm ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, your bond will be revoked. You will go to jail. No more PR bonds. Do you understand, sir?
Yes.
Okay. You have a license. You're not allowed to drive unless you have car insurance as well in your name. I'm making that also a condition of your bond. Do you understand?
Yes.
Do you have the ability to hire a lawyer, sir?
I'm sorry.
Are you working? What do you do in life?
I'm a mechanic.
What kind of
I
money?
can afford an attorney.
Do you want to apply for an appointed lawyer, sir?
Yes.
Okay. We'll give you an application. I need to know everything about you. Don't just put zeros because I'm going to send it right back to you. I need to know everything about you. And if you qualify, we'll appoint you a lawyer. But just remember, don't consume alcohol. Don't use illegal drugs. You understand, sir?
Yes.
Okay. Stephen will give you the application. I'll have you sign a receipt with Ramona, and then we'll have you take a seat in the jury box, sir. Did you want to talk?
Yeah, Judge, I've got a case, Derek Adams, on the docket. He was supposed to complete 2 classes by today.
Not do it?
No, he did, but he didn't pass one of them. And the contract doesn't require passing, it just requires taking. And so Ms. Saba, hey.
Judge,
we have the contracts.
I just needed chief approval that that's sufficient. I've never been in this situation. Like, I don't know if I can dismiss a case for failing an effective decision-making course, but attempting
Get
it.
this, Judge, there's not a single chief working today. So it seems like there's not really effective.
So let's roll it to tomorrow. Have him take it again.
I'm not coming back here.
Zoom in. That's why I have Zoom, to make it easier for you.
That's true. I'm appointed. Money's really tight for him. The
Case
contract
is 1,292 days old. We've given him how much grace to get this thing done over and over? Really?
And it was just 2 classes, Judge.
Last time, if you didn't have it done, you didn't have it passed, I'm carrying you day for day.
The contract doesn't require passing. I mean, I'm actually serious about that. Although it's funny.
I would be hard pressed to find a chief that's going to acquiesce to that. I mean, really, I don't know.
It was just, it was a pretty good PTI offer, Judge. It was just effective decision-making and a gun safety class, both of which are 2 hours. The effective.
Yeah, it's a 2-hour class, right?
Costs
Corey?
$22, I believe. There's no reason he shouldn't be able to do it again.
Just, a lot of times they don't take it seriously. So let's roll it to tomorrow, have him do it again, and then let him know we're going to redo it day for day until he gets it done. At nearly 1,300 days, I have no sympathy for this person.
What's the term? A collateral estoppel or something like breach of contract? It's not my bag of chips.
Remember, they're the ones that have the power to dismiss. I don't.
Right.
They're the ones, I just sign it. They're the ones who actually file the motion.
I know that.
So do we know when is she coming back?
I mean, Kelsey won't be back till Monday, Judge.
Okay, so let's roll it to tomorrow.
Yeah.
Have him take it again. Maybe he'll pass it this time. Tell him to pay closer attention. It's only 2 hours. It's not much. If he doesn't want to do it, okay, I'm just going to roll him to Monday. I'm going to keep doing it. It's 1,300 days. We got to take care of this. thing.
As long
I'm
as
gonna
I
set
have
for
a
trial.
chief tell me that the attempt is fine, like I just can't make that call, Judge.
Did you see how good of an attempt it was?
He failed it. It was like a 50%.
Somewhere around 57.
So
I'm rolling it to tomorrow.
is there a possibility that we're gonna have a chief?
No.
As long as there's another chief.
But if he passes, it gets dismissed.
Yeah, and I can ask another, like, if our bureau chief is here or one of our deputy dogs, I can go ask them after docket, Judge.
It's up to you.
Oh, I've been around everywhere. There's no chiefs.
Well, I mean, they would be on the 5th floor, Judge.
Yeah, well, regardless, I mean, we have a lot of work to do. We have 3 other courts that we need to cover as well.
Yeah.
So have him try it again tomorrow. If he doesn't want to do it, then we're just going to roll till Monday. Yeah, really.
Is Diane here?
He's here, yes.
Yeah.
I would, Mr. Emmett, you're set for a suppression hearing, December 12th. You have, at a minimum, got to look at every single piece of evidence that's out there before you even go to your hearing. It would be a fool's errand to go to this hearing without looking at every shred of evidence that's out there, because you have to know what they have and what they're going to use to prove. Today is time set for discovery. It is November 20th, 2024. It's approximately 11:49 in the morning. I'm going to have you guys announce yourselves for purposes of the record. Please state.
It's Emerson Nathan and
Morgan Harmon.
Judge, hold on. Can you have him come over so that I can see him? Emery, right here. Yes. Okay, go ahead. State it again.
Amber Nathan for the state.
Morgan Harmer for the state.
So what we have here today is we have Mr. Emitom. He is charged with unlawful carrying of a weapon. I want to say today is our third setting or fourth. I think it's our fourth setting today. Mr. Emitom has chosen to represent himself. I have done a Feretta hearing, found that he is and can represent himself. Mr. Emitom, are you sure you don't want a lawyer to help you out? Do you want a lawyer to just stand by to be able to answer any kind of questions? Okay, you still want to represent yourself. Understand that if anytime you would like a lawyer, I'm happy to provide you one at no cost to you that can advise you in any way that you may. So that is always at your disposal whenever you need it. At the last setting, we were working on discovery to see what was available. And the only thing, if I remember correctly, the only thing as way of discovery was an offense report that was in.
So Your Honor, the discovery is in, there is a video, there is a body cam and dash cam that's in. The state has tried to reach out to Mr. Emitom to schedule a time for him to come in to review this discovery. It is the state's policy to not give this discovery out of the office to pro se defendants. He is here today. We can coordinate with our investigators for him to come and look at what we have. There is also a motion to suppress filed on the same transaction felony out of this, and that is scheduled for December 6th, 15th, I believe, or 9th.
December 12th is my next.
December 12th, okay.
December 12th.
Are you representing yourself in the felony case as well?
Yes.
Okay.
Judge Lacayo did find him competent to do so, and we are having a suppression hearing on the 12th of December for that case.
Okay.
So if the evidence is suppressed, both cases would be resolved based on the search. Because unlawful carry is tied to our transaction. It is a commission of a felony offense. So if our case goes away, your case
Are
goes away.
you upstairs as well on his case
I'm on the
upstairs?
felony case,
You're on the felony case. Okay, great.
I know the last time we was here, I did the suppressed evidence. Are they doing the misdemeanor and the felony together with the suppressed evidence? Because I emailed, I don't know if it's Anna or I have it on my email. I emailed Friday, tried to review the evidence, but I didn't get a response. I got a response to come tomorrow at 1:30. I didn't make it in town till yesterday night.
So the defendant emailed me on Friday and he asked, he reached out to review the evidence. I requested a cause number. He provided the cause number and I sent on Monday at 7:20 a.m. Would tomorrow work to review the evidence? Please let me know if you have a preferred time. I'm available anytime after 1:30 p.m.
Here now, is it possible to do it now?
Let me
Or
coordinate.
perhaps later today, since he's
Later
here?
today. Let me go talk to our investigators, make sure they can supervise him and.
You're here now.
Yeah.
I would, Mr. Emitom, you're set for a suppression hearing, December 12th. You have, at a minimum, got to look at every single piece of evidence that's out there before you even go to your hearing. It would be a fool's errand to go to this hearing without looking at every shred of evidence that's out there, because you have to know what they have and what they're going to use to prove, you know?
Last setting they did go in the back room and let me see whatever was like the report that was typed up and everything. So I was able to.
That's just an offense report, but here he's saying there's body worn camera.
Body worn camera, there's another video as well that was uploaded as evidence. And then I believe there was an image of the stolen check. That was.
You want to talk to your investigator now, and
Yes, I'm good.
can you stay here and perhaps maybe like at around 2:00, meet them at the office and then go through all the evidence then? Is that okay?
Yeah, I can do that. I can.
You're here.
I mean, yeah, I can do that now.
If
You
tomorrow,
might
if
as well.
you want to come in tomorrow morning, that gives us time, but he has to confirm with us because ADA Harner has emailed him and he has to make that call. Like he can, I don't know, the body cam could be 4 or 5 hours of body cam because there's multiple body cams. I don't know if our investigator is going to stay till 7 o'clock to review body cam today.
That's a good point. So
if you're available tomorrow morning,
do it tomorrow morning?
Yeah, that's fine. Also, are they gonna have the medical record for the hemp? Are they gonna have the?
So that is the one piece of evidence we're still waiting on, Judge, is the lab for the marijuana.
Check the charging instrument.
I'm telling you, it's based on it.
That takes a long time. Mr. Emitom. It takes a long time.
Had the receipt from, because they had Montana Doyle that was claiming that. I do have the receipts and she was my witness. That it said that she was claiming that. It said it in the report. So my witness could come and do the testimony or whatever.
But that's at the hearing.
Okay.
You do that at a hearing. You don't do that here as part of just evidentiary sharing, right? It's not, no one takes testimony now. No one decides.
That's when they said she could do it with the clerk. When I did have her here, they said that the clerk could.
You mean just filing an affidavit?
Or whatever she needs to do to say,
I mean, I can't tell you. You're representing yourself. That's why you usually have lawyers that kind of guide you on how to get evidence admitted, what kind of evidence gets admitted. I can't give you legal advice and they can't tell you either.
Yeah, they said I could submit it to the clerk. That's what they said. The witness could come to the clerk and do.
Who is they? We didn't say that. All I said is that if you wanted to file an affidavit, yeah, something like that, but.
I could do that.
So can you talk to your investigator, see
Yes, I'm gonna do that
tomorrow, perhaps like at 9 o'clock in the morning?
9 o'clock.
So he goes at 9 o'clock. That way it's early. He can stay for as long as he needs to do it. And then if you guys can also provide me with an address of where he needs to go, what floor, perhaps give me a contact name and number just in case as well. So your investigator, that way, if he should have any issues, he has a contact to be able to speak to someone as well. Because if he tries to go through the regular phone system to talk to him, man, he'll be beating his head against the wall. Okay, so just hang tight with me, Mr. Emmett. I'm gonna have him talk to the investigator, see what time, make sure 9 o'clock tomorrow is good. We'll find out where you need to go. We'll give you a sheet of paper with time, location, and a contact for you. You go review everything. Our case is now 11/20. Today's November 20th. Do you want to set it for after the suppression hearing, since you guys are gonna do that over there?
And honestly, I don't even think that the marijuana was sent to the lab, Your Honor. So
I put in a lab request, Judge, myself. I'm not sure if the officers provided it, but I put in a lab request.
okay, if you put a lab request, like I don't know when the.
We'll cross that bridge when we get there. If the officers aren't doing what they're supposed to be doing, go. You know how I feel about that. So how do you feel about that? We'll set this case maybe one day after your hearing upstairs on the 12th.
Yeah.
And like they said, if you win that hearing, this case goes away. If you don't win that hearing, then we'll deal with this case the day after and see how we move forward. Okay?
Okay, thank you, Your Honor.
All right, so we're off the record. All right, so just hang tight for me. I'm gonna get all the information for you and then just look at everything that's out there. All right, got to, okay? And now he's still consuming alcohol, Mike.
That's what I'm saying. He's here to tell you, I don't believe that's the case. He swears up and down he didn't. He puts.
Have a scram.
I understand that. And he puts a crazy amount of makeup on him and the alcohol, I gave you the pictures of it also. It's called alcohol, what's it called? Hang on, he can explain it to you, but I have it here.
I have pictures of.
The nature alcohol can be mistaken for alcohol consumption. I know.
I have these pictures. It has no date. It has no.
To give you context to it, I have the dates here. Those are just pictures of the close-up makeup, but he was DJing on those particular dates. And I have it right here because I was trying to get it in the club.
And I guess drinking while DJing, right?
No, he wasn't. I mean, you talked to him. I wasn't there. It was DJ Sidney Ray, October 31st at this place, and that was the day in question. And then this is October. This one, I'm sorry.
Okay, so
October 27th.
I have here that you're consuming alcohol. I have here that the consumption is October 26th.
Yeah, that's the. I believe
October 30th.
November 9th.
November 9th. Oh, and October 9th. So I have 4 different events that you're consuming alcohol.
For October 9th, Your Honor, that was whenever you told me to put the scram on, and I put the scram on right after that. And then those other 3 dates.
So you're allegedly consuming alcohol the day I tell you to put it on.
No, he did it. That's the day, and then he put it on. No, that's the violation. We addressed that.
I have a positive for alcohol on the 9th of October.
Not from the scram, I think.
Yes.
October 26th.
I sent him on 10/9. So Felicia,
Yes, sir.
so we sent him for a POC test on 10/9 on that time. Did he test positive for alcohol?
Yes, sir.
Why on earth are we just now getting the violation?
The violation was already addressed.
That was addressed.
Yes, that violation was already addressed in a previous BVR. They started to put it in that section, that's why I didn't highlight it, but I
Can I
don't,
address that BVR?
yes, and that's when we amended the conditions to put a scram.
Okay, so now we have alcohol consumption as a second violation on top of all this.
For the scram itself.
I've been very grateful for the second chance you gave me. That was from the makeup that I applied to myself, and I was just ignorant to the fact that that would actually set off my scram device, but I have not consumed another alcohol beverage at all. Those are also the days that I was working, I was entertaining, I did not consume another alcohol beverage at all, so I've been very grateful. I'm not stupid, I wouldn't consume another alcoholic beverage after you put the scram device. in
Mr.
the cellar.
Burrows, I told you at every single stage of this game, do not put anything into your body that could be positive for alcohol. It is your responsibility to know what you can and cannot use. You're old enough to know that actions have consequences.
Yes,
And
sir.
here we are. I've already let you go one time with a positive for alcohol. When I told you not to consume, you literally tested positive on the day that we sent you for the test. And now we have another 3 positives for alcohol.
I don't think that's out, that's the part, the other parts, yeah, but the first part, that's not, he didn't test positive.
He tested positive 10/9.
No, that was,
It was a positive urinalysis test, and because of that, we amended the.
And because of that, I amended the conditions. I did not put him in jail. I put the scram on him.
yeah, but we addressed that he didn't go in and like.
I got it.
It's not 2 tests, is what I'm trying to say.
Okay,
You're right.
but he's continuing to consume. Stephen,
The scram reports are also in your email, I'm not sure if you picked them, but we got the notice of the records as well for all of those dates.
have you seen that?
I have whatever I was sent yesterday.
That's it.
I'm sorry, Mr. Bros. What am I supposed to do? Just let you go again?
No, sir, I'm not asking to, and I did not consume any alcohol. It was just yes, sir. The products that I put on, and I just was not aware that that was set off that. And it was makeup, sir. That's all it was. I didn't consume an alcohol beverage at all.
That party is 10:31 and I have here 10:26, 10:30, and it's you're telling me that you put this makeup on November 9th? Is that what you're trying to tell me?
Yes, sir. It's for my TikTok, and I have the videos of it also, sir. I do cosplay, and I just put on those products, and that was the sweat from it. I had no idea that that would actually get inside my blood system and and set that off.
You have levels?
Yes, they're in the scram report.
What is it?
I have.
It's like a peak of 0.08, and then.
He's a 0.08.
Yes.
You're telling me that makeup made you a 0.08?
Yes, sir. And those are the days I was at work.
I don't believe it for a second.
I even have.
I don't believe it for a second. I'm sorry. A
Understand.
0.08 because of makeup?
Yes, sir. I understand. I promise you I have not consumed alcohol at all.
I'm sorry, dude.
I understand.
That's it.
Yes, sir. I understand.
With you.
I understand, yes, sir.
And possibly believe that makeup is going to make you as intoxicated as having 6 to 8 drinks. Where's mom? Are you mom? Come on up, mom. Thank you so much for coming. I want you to understand that the last time we were here, your son tested positive for alcohol, and I told him that there was absolutely just no tolerance. And I advised him to know what you put in your body, because it doesn't matter if you test positive. I go through a whole spiel: tequila, lollipop, hair dye, just cakes, candies, foods, gums, energy drinks, whatever it may be. You test positive, I'm going to end up revoking your bond. We've already asked him once. I put a monitor to ensure that he's not consuming alcohol. This is not the first time we were here with the DWI. We're here yet again on another one. I understand that the other one was dismissed, but I guess it wasn't enough to catch his attention. And now we're here yet on another one, and he's continuing to consume. And it's not just once, it's not twice, it's not thrice, it continues to happen. So as a result, I have to show him that we mean business. And as a result, I have to put him in custody.
I've been on him, and I know hasn't been drinking, but, but I can't argue, but, I know he hasn't drank.
He has to know that you're on bond for a very serious case. We've asked you and told you not to use anything that has alcohol in it. And I cannot believe that makeup will cause you to be a 0.08. That's literally the legal limit, 0.08. That's usually someone consuming, a typical drink is around 0.02. So to get to a 0.08 and whatever, based on time frame and everybody's different, but it's a lot. So I'm sorry, man. That's why we put him in. Mike, I'll set the bond at 5,000. I don't know, what's it at now? Okay, I'll set it at 5,000 too, so it's not. And then we'll see,
During my way to the court, and I am in jail, right? What happened to me? They took me to the hospital for my bad condition. 7 hours, we try to reduce my blood sugar. 3 times give me insulin, it's still high. They refuse to send me to the court. This is my condition, sir.
How do I know that?
I just explained to you.
Do you know how many people tell me the sky's purple?
I'm not lying, sir.
Yeah, Mr. Scott, that's Briggs for the plea, and Mr. Khalifi for Mr. Ely right behind him.
Come on up, guys.
Come on up.
Oh, we got it.
I'm gonna talk to you, but let him finish first.
All right. Good morning, Mr. Scott. Mr. Scott, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 90 days in jail with credit for the 27 that you've already done.
Should be. Okay.
Yeah.
I was 29, but.
You should be 29.
Really? Look at that.
But I was told because it's.
Going to bat for you. That's pretty cool. DA's going to bat for you, man. That's good. What?
27.
It's been 27 since October 25th, but he was initially taken in on the 7th, in July for the same charge. There was no PC and then refiled.
Okay. I'll give him 29.
Thank you.
Not a problem. All right. So, Mr. Scott, but, regardless, you have to understand that it's going to go on your record. Have you been to the pen before? Yeah. Next time you pick up a serious felony, it could be a 15 to life case.
If I may, just so the court is aware, and I explained to him the ramifications, he is on parole currently for the enhancement.
Sometimes, a woman is like a piece of cancer. She'll kill you, dude. She'll absolutely kill you. How can someone get into your head so much, twirl you up so much that you lose control, no matter how small it is, to where you end up in a box for the next 3 months? Not only that, it's very possible they revoke your parole, send you back to prison now. So many other fish in the sea, just go find another release, because life's too short to live in and out of custody. You know what I mean? This applies to you, Mr. Khalifa, as well. How are you going to let someone get into your head so much so, you cut the cancer out before it kills you? How do you plead to the offense of assault family member? You also have to understand, because you're on probation or parole, this could be used to revoke that. It could result in further confinement. Is this what you want to do? You sure? Okay, man. I'm going to find you guilty. I'll send you to 90 days in jail. Is it enhanced, Greg? Do you know?
It is with a felon in possession of a weapon.
Is it true that you had that felon in possession? Okay, true to enhancement. Mr. Scott, come on, man. Life's too short. Mr. Ely. Thanks, Greg.
Your Honor, I'm motion for on bail review for Mr. Khalifa.
Mr. Khalifa, I know that you're telling me these things, but we have a complaining witness that has been calling, saying that she's terrified.
Can I say something, if you don't mind?
But remember, everything that you say, they can use it against you. Don't. Did you want to say something?
Oh, Judge, I've already kind of explained to you the continuous contact and bond violations that have been occurring. I think it's important to note that this individual had 3 warrants out at the same time. He failed to appear, obviously for the misdemeanor, for the felony. His warrant was sent out for violation of bond, violating the exclusion zone. I received calls nearly every day from the complainant telling me how scared she is, that he is continuously trying to contact her. He has canceled her credit card. He is trying to call her from blocked numbers. He is continuously violating his bond. He has stated himself that he does not care about the protective order.
I would object to hearsay, Your Honor. I know he didn't come to court. He has been sick with diabetes.
Can I say something, sir? Sure. Yeah. Okay, as the same day I have a court, I was here, by the way, and I thought.
You weren't.
Sir, can you give me second judge? If you don't
Sure.
mind? I wasn't here in the building. I was here around this area. My blood sugar.
Doesn't count.
Can I say something? I talked to the sheriff to take me to the court. He told me just to keep going and the bark is there and to go. I feel down, my blood sugar was so high until like maybe I get up. Some people, they broke my door to open it because I'm diabetic, it's a very bad condition. When I get up, I don't know what time, it was like 4:30. I show up at the court here, they told me it's already done. Come back Monday. When I come back Monday with my other attorney for the felony, you know what? They told me it's closed today, the court. So you don't have to be there. Just to be patient until like we give you court. So I wasn't Skype, sir.
Okay. Your Honor, I will say they haven't brought him here the past 2 days.
Can I say something also too? Yesterday I have a court here, right? During my way to the court and I am in jail, right? What happened to me? They took me to the hospital for my bad condition. 7 hours, they try to reduce my blood sugar. 3 times they give me insulin, it's still high. They refuse to send me to the court. This is my condition, sir.
They want to make sure that before they bring you to court, you're in a good
See what
condition.
I'm talking about now? I'm not lying, sir. So why I escape if I have a court?
You weren't here.
Exactly, because my bad condition.
How do I know that?
What I argue you right now, to waive the bond, the fees.
Regardless, you don't come to court.
I told you what happened, sir.
How do I know that?
I just explained to you.
Do you know how many people tell me the sky's purple?
I'm not lying, sir. Because I'm very sure, even yesterday I have important court, I cannot make it, and I am here already.
Your Honor, his bond has been denied on the felony, so even if you did lower it, he's still
You see what
won't be
I'm
able to
saying?
get out unless they.
Exactly.
Felony court has revoked your bond and you're at 0 bond.
That's zero.
Even if I were to tell you, look, go, be fancy, be free, your felony court has made you no bond, so there's nothing that we can do at this point anyway.
No, just to waive the fee. And I have another thing about what she was telling you, sir. Yeah, I have the approval. All of this is a scam, by the way, because I'm the one he got message, very scary message.
I would like to know, do you have, other than her word, any kind of documentation, any kind of evidence to show that he is violating conditions of his bond? Because I would like to see it. Because I would like to show it to Mr. Khalifa if in fact you have something.
Correct.
I have screenshots from the complaint, so if I may kind of explain, it's a little complex. So they're
interrupt.
still legally
Finish.
married, they're still legally married, they're on the same insurance plan.
We are not in an insurance plan, we are not legally married. I applied for divorce. I'm sorry. Okay, I'm so sorry, I'm not gonna talk no more. I promise you, I'm not gonna talk no more.
Control
I promise you.
self. This tells me if you're incapable of controlling yourself, this tells me a lot about you.
Just because my bad, the blood,
Stop.
I'm not talking no more.
So that you're still legally married, that shared an insurance plan. While he was on bond, he called to amend it to raise the rate and then have all of the money for the insurance plan taken out of her account. Now that would only be permissible, obviously, by one of the holders of the plan. She did not do it. I have screenshots of that from her judge. I have a lot of evidence that she's sent me, provided me. I understand that it's hard for you to believe if it's like blocked numbers. I understand your hesitation with that.
Show me. I mean, if you have block numbers, if you have 50 block numbered calls, that's something, because that's not something that would normally happen. Well, I get a lot of calls from scammers and crap, right? But I mean, if you get 50 block calls in a very short amount of time, I know that's Morgan, you don't have to do it just this very minute, right? But I would like it like really, really soon.
Absolutely.
And what I want to come back within maybe a day or two, and I'm going to show him, look, this is what we have, this is what we don't have. If we don't have anything, then, but I understand if she's scared, but show me the money. I want to see what you have.
Just, can we move it till Friday? And then
Sure, of course.
if the state can send that to me too?
Yeah, absolutely.
Okay.
But I want to know why is she so scared? Why? You're itching to say something else. What did you want to say?
Remember when she said I destroy her car?
No, I don't remember that.
Yeah.
We're not getting it.
I want to see the video.
Okay.
You will.
The video has been uploaded and shared.
You will.
Okay.
And everything that they have, you will get to see.
But you promised me you dismiss it if I didn't touch her car.
I'm not going to promise you.
I
What are you,
didn't touch
you
her
crazy?
car.
I can't dismiss something.
I did not touch it.
Okay.
If that is the fact, then the evidence will point to whose side is correct. I don't know.
Just stand by her mirror.
But you have to understand that it takes time to get evidence. And we will get it. And as soon as Mr. Ela gets it, he's going to show it to you.
Just argue for the bond, make
Okay.
it reduce.
We're gonna come back.
First talk to felony court because you're at no bond over there. And then if you get something in felony court,